Lordships leave to mention one matter. I know that this is a normal mentioning date, but under compelling circumstances, I mention this matter. This is a Section 34 application of 2024. It's in the list. But the thing is that when this was referred to the arbitral tribunal of Surajit Nath Mitra, now the present AG, my lord, a deposit of 40 lakhs was asked to be deposited in FD, Nationalized Bank, in my name and the other side's Advocaton Records name. Now, I being now a senior designated advocate, I don't want to continue with that deposit. Well, Lordship, kindly fix it up any day to be mentioned. It will be a short matter. It can be disposed of any time.
Can't be done like this, sir. Move an application, appropriate application.
Well, this application is pending. Section 34, they have challenged.
Section 34, you want your name to be, the order to be modified, right?
Yes.
So you have to move an application.
I will file that, but Section 34 also, if you...
Pending, I get it, 34 is pending.
Yes.
But if you want this kind of a correction in the order, this can't be done in to be mentioned.
All right, my lord, I'll file that, but in that also, my lord, I'll beseech your lordship, kindly hear that Section 34, it will take only 2-3 minutes to dispose it of. If it is dispose it of, nothing like that, they will get the money and all.
So you have become a senior. You only want that the money should not be deposited with you.
Yes.
Leave apart the 34. That's none of your concern.
Yes,
move an application, seeking appropriate direction.
For the petition.
But move an application.
Well, your lordship's kindly to mention item number 79 of your lordship's list, my lord. This is a bank guarantee invocation matter, my lord. The threatened invocation is on the 7th of August, my lord, which is when the bank guarantee is stated to expire. I had mentioned this on Monday, my lord. The lordship was pleased to allow it, but it's come as item number 79.
That's okay, but we are not reaching 79.
Certainly, my lord.
Are you not watching the list? Where are we going? Where are we heading?
Right.
Are we not reaching?
No, I will await my turn.
Then we reach on Monday, Tuesday. What is there that we will not reach today?
Very good, my lord. I will await my turn. I beg.
My lords, I'm afraid a similar request, but my lords, I had mentioned on Monday, my lords, this is item number 95, my lords. The case of Steel Authority versus McNally, my lords. This company has recently come out of CRP.
No.
My lords, I want to...
You are there in the list, that's it. Nothing more.
My lords,
we'll see whenever we can hear it, we'll hear it.
I want to pray for an upgradation, my lords, or a time fixed.
No,
my lords, it won't take more than 5 minutes, my lords. It's a very... this issue is settled by multiple...
No upgradation right now. It is there in the list. It will come.
My lords, that's 95, my lords. I bow down, my lords.
I have put it in the list.
Grateful, my lords.
That's enough.
Should I, my lords, hand it over, my lords?
No need. You are there in the list. We'll see it.
I'm grateful, my lords. Grateful.
My lords, kindly to mention
one matter. Inclusion in the execution list, lordship.
Execution, not in the list.
No, it's not in the list.
My lords, kindly leave to mention, my lord. I am seeking to file a appeal, my lord, under section 37, challenging an order under section 16. This is a soft copy of the order. That is all that I have received from the erstwhile advocates. The petitioner has received. I have not received any other. And I have approached the arbitrator. She has said that unless I have an NOC, she will not allow any, even my representation. This is the order that I have received from the learned arbitrator from my erstwhile advocates.
Can't be, sir. You have to get the order.
This is not an award within the meaning of section 31(6).
Yes.
There is an order under section 16. Where the jurisdictional challenge in respect of a third party, whether he is bound by arbitration clause or not, has been decided. That is appealable under section 37. It is not an award. 31(6) will not apply.
We'll see that first. Get the copy.
This is what I have received, but it is unsigned. This is the difficulty.
You have to get right to her.
I have approached, but she's unless I have an NOC, and there is some. I don't want to make any complaint, And today
you have to manage it, sir. I can't help you with that. Talk to your erstwhile lawyer, whosoever is there. Whichever way you have to manage it. I'm not going to allow on an unsigned order sheet.
I have received this by email. Email. If I can produce
unsigned order is no order for me. No, okay. I will not allow my registry to take an appeal with an unsigned order.
Although I've received
I can understand. This will be very unfair on the part of this court to ask the registry to accept something which is unsigned.
I can understand.
Wrong practice. Disputes between you, your erstwhile lawyer, arbitrator, none of the court's concern. It's not our problem. Problems are created by the client where he fails to pay the, erstwhile lawyer.
Don't want to go
New lawyer is
That is why I
whatever.
don't
These are the things which we all, you think we have come from somewhere else?
Of course not. Of course not.
5 years back, I was also there. Don't we understand? So don't make those prayers.
My lord, may we permit to mention, my lord, 2 Section 11 applications for inclusion, your lordship. The matter was last heard in February, your lordship. The matter was supposed to appear after 2 weeks. Thereafter, my lord, this matter
It
has
is
not appeared.
34.
Section 11, my lord. 2 applications, same parties, my lord, if this could be included.
May
So
Your Lordship leave to mention a matter for upgradation. Your Lordship, this is an execution application arising out of arbitration award passed by MSME Council. Lordship, my award is unstamped. I have filed an application for the leave of this court to get the stamp.
Unstamped
Yes, Lordship.
award execution, I'll dismiss it.
Lordship, I have filed an application for the leave from this court so that I can get the award stamped, impounded. Lordship, if it can be heard.
Why should I unnecessarily advance it? What is the urgency in this?
Lordship, the award is passed in the year 2017 and the matter is still pending.
Wait for some time.
Instant matter, item number 1.
Lord,
Yes.
Justice Jyotirmoy Bhattacharya.
Lordship will record that upon instructions.
Yes, obviously.
Because the state so well.
Take down. The present application has been filed under Section 9 of the Arbitration Conciliation Act, seeking interim relief in the nature of stay on the order dated 5th January 2026. Restraining the respondent from taking restraining the respondent from interfering, infringing, or threatening to infringe the petitioner's right, title, and interest and peaceful possession and occupation in respect of the leased premise. Full stop. Without getting into the merit of the matter, learned counsel for the parties submits that an arbitrator can be appointed to adjudicate the dispute between the parties arising out of the lease deed dated 20th April
20th April 1993.
20th April 1993. Full stop. With the consent of the parties. Retired Judge,
Yes, Lord, former Chief Justice, Lord.
Honorable Justice
Jyotirmoy.
retired Jyotirmoy Bhattacharya is appointed as the sole arbitrator to adjudicate the dispute between the parties. Full stop. All points and contentions regarding maintainability, arbitrability, claim, or any other issue shall remain open to be adjudicated upon by the learned arbitrator. Full stop. The learned arbitrator shall enter reference in due compliance with Section 12 of the said Act. Full stop. He shall be entitled to fix his remuneration in terms of the 4th schedule of the said Act or with the consent of the parties. Full stop. The present Section 9 application shall be treated as a Section 17 before the learned arbitrator. With the aforesaid direction, the present petition stands.
Lord, 7 days, my Lord, to move before him.
Yes.
We will communicate today 7 days for his Lordship to give us a date to move.
We'll stay it for 7 days. No coercive action. Or you will not take any action.
Will not take any action.
Will not take any action. They're not taking any action.
Kindly record that. But it's state after all. You never know.
Learned counsel for the learned senior counsel for the state upon instruction states that no coercive action shall be taken in terms of the order dated
5th January.
5th January 2026 for a period of 2 weeks. Move before 2 weeks
Grateful.
for a period of 2 weeks. With the opposite
Grateful.
action.
This application can be disposed.
Yes,
of.
yes.
Disposed. Great.
Item number 2.
My lords, I am appearing for the applicant, my lord.
You're for the
3 and 4, my lord. My lords, on the last date of occasion, my lords have directed me. My lords, there is the affidavit of service, my lords. Because they have appeared also, my lords.
Yeah, there.
My lord, may I pray for only one indulgence, my lord?
Yes.
My lord, GA 3 and 4, my lord, it was perhaps served, which I get to know now, but it has. Lord, not all the GAs which are before your lordship for consideration is with the state, my lord. May I come back with only after 2 days, my lord, after acquiring the 2 copies, my lord, because I.
Because this is a restoration application.
I understand there is a restoration. There are 2 restoration applications, as I understand, because I have not gone through the applications, my lord. I can only fathom that out from the records which are available, my lord. So, my lord, if my lord kindly grants me 2 days' time, my lord, I will acquire the other GAs which are before your lordship for consideration, which I understand from my learned friend is a restoration application, my lord. I shall make my submissions on that.
You have
No,
got
my
the
lord.
copy of the GA?
There's the notice of motion. Yeah, but this is not the GA. This is GA 4. So, my lord, GA 2 of 24 is also not with us.
My lords, GA, that is not listed today. Only GA
That is
3
3 and 4 are listed.
GA 3 and 4 are listed, my lord.
3 and 4,
Are listed today, my lord.
they are not with us, my lord. At least not with me, my lord. I have taken instructions from the learned AOR's office. It is not there, my lord, as well.
Yes.
You have the GAs.
3, yes, my lords.
GA 3 is there. That is the restoration application.
My lord, as my learned friend assists me, my lord. My lord, the GA 2 is also a restoration application. My lord, GA 3 is also a restoration application. My lord, if my learned friend only gives me a day's time and serves it to me, my lord, I can come back and make my submissions. GA 2 of 24 is relevant, my lord, because
GA 1 is also a restoration.
My lords, we have served them the whole set along with the AP as well. My lords,
my lord, I am a little handicapped today. My lord, Granzi gives me a 1 day's time.
All right, not today. We'll have it day after tomorrow.
okay, my lords.
I'm so grateful.
Obliged, my lords.
GA 3 is a
Restoration.
restoration application for GA 1.
Lordship.
My lord.
Lordship.
GA 4 is a restoration application for
For
GA 2.
Yes, my lords.
So that is how it works.
Yes, but
So
GA
1, 2 gets taken care of in this 3, 4.
Yes,
Lordship. But 2 is also something which we do not have.
That's what I'm saying.
Yes.
That is
that's
also a restoration.
right. But the application is also not there with us. My lord,
My
once
lords,
that
we
is
have served, we
restored,
will serve again, my lords.
once
We
that
have
is restored, it will fall back to GA 2. My lord, I have to make my submissions on that as well. My lord, only that. I'm so grateful, my lord.
Obliged.
And now 4.
That content application, the settlement agreement has been signed, 4 lakhs has been given, and it's an admitted fact that they have received the 4 lakhs and 1 lakh rupees post-dated check, they have received it, they have accepted it.
Yes.
This is the entire
Lord,
thing.
that check is to be encashed in.
That's all right. It will get encashed.
Your Lordship may kindly dispose this, but
I'm-
not kindly puts a default clause, only this much.
Fine. Take down. Learned counsel for the parties submit that the matter stands settled between the parties. Full stop. A check of rupees
1 lakh, 1 lakh.
has been given in favor of the petitioner. ऐसे कर दो. The respondent had paid a sum of rupees 4 lakhs earlier,
Yes.
and a check of rupees 1 lakh has been given to the petitioner as the full and final settlement between the parties. Full stop. The said check is to be encashed in the month of
30th
October.
30th October 2026.
in the month of 30th October in the month of October 2026.
Yes.
Full stop. Learned counsel for the respondent undertakes
Yes.
that the said check issued in favor of the petitioner will be honored and that no default should occur
Yes.
in regard to the said check. Full stop. With the aforesaid direction, and in view of the fact that the matter stands settled between the parties,
Humble
learned
request.
counsel for the petitioner seeks to
They are to
draw the
abide by the terms and conditions of the settlement agreement.
That's in the memorandum. Very
equal line. Equal line. In view of the settlement arrived at the parties undertake to abide by the terms of the settlement entered into in the MOU dated
date of यही तो date है तो ऊपर
May 2026.
signature date है May 2026
27th May 2026. Full stop. In view of this said settlement, learned counsel for the petitioner
actually I did
seeks to withdraw the present petition. The same stands dismissed as withdrawn in the above terms.
grateful.
Section 29A, item number 5.
This is my application under section 29A of the Arbitration and Conciliation Act,
Yes.
that's seeking extension of time of
The file.
the mandate of the learned arbitrator.
Yes, yes.
Only argument of the claimant, so far as the reply argument is concerned, is remaining and the award is to be passed on. The
The petitioner has preferred the present petition under section 29A4 of the Arbitration Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for publication of the award.
for concluding the argument of the claimant and for publication.
For conclusion of the arbitral proceedings and publication. This court, by order dated 27/6/2023, had appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The proceedings were completed on 18/12/2023. Full stop. The parties, with mutual consent, extended the mandate of the arbitral tribunal for a period of 6 months till 18/6/2025. Full stop. Thereafter, this court, by order dated 29/7/2025, extended the mandate of the arbitral tribunal for a period of 1 year. Full stop. Learned counsel for the petitioner submits that the matter is at the stage of final arguments. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the material placed on record and the arguments advanced by the learned counsel for the parties, this court is satisfied that no undue or unwarranted delay is attributable to the learned sole arbitrator in conducting the arbitral proceedings. Full stop. Having regard to the advanced stage of the arbitral proceeding and in the interest of justice, the mandate of the arbitral tribunal is extended further for a
We
period
have
of
prayed for 2 months extension.
3 months
3 months.
from the date of the order. The learned sole arbitrator is requested to conclude the arbitral proceedings and publish the award within the extended time period with the aforesaid direction. The present petition stands disposed of.
Obligation.
Lordship, this is my application under section 29A. On the last
And not
occasion,
take.
your Lordship. Pardon, Your Lordship.
Yes.
On the last occasion, your Lordship has extended the mandate. At that point of time, arguments were going on. Lordship, that would be seen from page
Annexure J.
J.
Page.
Page 44, your lordship. Page 44.
So what is the stage now?
Your lordship, hearing
The award
stands
is required
concluded,
to
only the award is required to be passed.
Everything.
Everything is completed.
पहला paragraph same होगा. This court, by order dated 3rd February 2026, had extended the mandate of the arbitral tribunal for a period of
6 months.
6 months. Full stop. Learned counsel for the parties submit that the arguments are concluded and the matter is listed for publication of the award. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of
5 months.
5. It's a big award.
We are being on the safer side. Anything your lordship deems fit.
Lord, if your lordship may only consider, my lord, in the extended time, if the puja vacations, my lord, can be included. That would enable, my lord, to the benefit of the learned arbitrator.
So, 4 months would be enough.
Yes, my lord.
For a period of 4 months from today. From the date of this order, full stop. The learned sole arbitrator is requested to publish the award within the extended time period. With the aforesaid direction, the present petition stands to be closed.
Grateful.
उसमें बोल एक लाइन लिख लेना. Learned counsel for the respondent has no objection to the extension of the mandate of judge.
Grateful.
Lord, I am appearing on behalf of the petitioner, my lord.
I appear for the
My
respondent.
counsel is
My lord, in this matter, I am appearing for the petitioner, my lord. This is my section 29A application. My lord, here the arbitrator is Honorable Justice Shubroto Talukdar. And my lord, we are at the stage of cross-examination of the respondent's witness. My lord, if
He is the respondent.
I'm appearing for the claimant before the
Declared by
arbitrator.
Yes.
Sharma.
My lord, we are not objecting. We are, in fact, this is a joint prayer for extension of mandate. At this stage, my lord, I was examining the witness of the
Respondent's-
respondent. RW1 was being examined. Respondent has 2 more witnesses after this. So RW1 cross-examination has just commenced. So, my lord, the 1-year period expired on July 2, 2026.
26.
So I was praying with if your lordship kindly give us a 1-year extension. Because a lot of evidence will be required to be completed.
There is still 2 more witnesses, my lord, and thereafter arguments, and in between puja vacations are there. That is why, my lord, we are praying for 1 year.
1 year.
Joint prayer.
The petition has preferred same paragraph same. This court, by order dated 14/5/2024, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed and the parties, with mutual consent, extended the mandate of the arbitral tribunal by 6 months till 2nd of July 2026. Learned counsel for the parties submit that the matter is at the stage of recording of evidence.
Yes.
Full stop.
Respondents.
Learned counsel for the parties submit that it's a joint prayer to extend the mandate of the arbitral tribunal to conclude the arbitral proceedings and for publication of the award. Full stop. Upon consideration of the material placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator. Full stop. Having regard to the stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of 1 year. From the date of this order, the learned arbitrator is requested to conclude the arbitral proceedings and publish the award within the extended time period with the aforesaid direction. Present petition stands dismissed.
Grateful.
Much obliged, my lord.
Filing the
Great.
My lord, in item number 8, my lord, I have been appearing for the petitioner.
Motion item number 8.
Yes.
My lord, this is an contempt application, my lord. In this application, my lord has already passed an order
Yes,
citing the section 17.
In view of the judgment of this court in APOT 297, right?
297, my lord.
297. In view of the judgment of this court in APOT 297 of 2025, nothing survives in the present petition. The same is dismissed as infructuous.
Lordship, I am for the
Much
response.
obliged.
Obliged.
View of the judgment passed in APOT. Yeah? View of the judgment passed in APOT.
Much obliged.
Around 9. May it please your lordship.
Item number 9, I appear for the respondent, my lord. My lord, although my lord, affidavits are complete, my lord. However, my lord, a preliminary point was kept open with regard to the maintainability of the arbitration, my lord. My lord, our contentions are, my lord, there are 6 separate purchase order, my lord, with regard to 6 separate locations: Chennai, Bhubaneswar, my lord, Haldia, Hooghly, Kolkata, my lord. Each and every arbitration clause contains, my lord, separate arbitration clauses, my lord. The parties were ad idem in treating the arbitration clauses as the contracts as independent, separate, and distinct, my lord. And my lord, the only reason for clubbing, my lord, all the 6 arbitration proceedings, my lord, today as on date, is to, my lord, escape the point of limitation. Because, my lord, I will show your lordship from the documents appended to the section 11 application that most of the invoices are, my lord, time barred. So, my lord, in order to, my lord, show, my lord, it's a composite transaction and the last date of payment, which has been adjusted against a particular project as well. My lord, they are trying to, my lord, escape limitation by clubbing it, my lord. My lord, that is the moot point, my lord, for which, my lord, I would wish to take your lordship to the various documents, my lord.
Yes, my lord. Since I have already submitted this at the outset, my lord, on the last occasion.
Day one, this court is of the view that there should be separate.
My lord, I have indicated in my supplementary affidavits that on the basis of the conduct of between the parties, my lord, part payments were made whimsically by the respondents.
Conduct cannot give rise to a section 11.
My lord, I'll just indicate. Let him submit your lordship. I'll indicate, my lord, from my documents.
Very good, my lord. May I, my lord, place, my lord? My lord, first, my lord, the section 11 petition, my lord.
If I may just humbly, my lord, before he submits your lordship, I'll just indicate, my lord, there are 6 purchase orders which were issued by the parties in respect of supply of ply products to the respondents at various sites. My lord, the sites are in control of the respondents, and your lordship, in respect of these purchase orders, the supply of these goods were made. Accordingly, payments, what we are awaiting is regards to the payments of the supply that was made. The last payment, your lordship, there was no indication about that these payments will be treated separately. Payments were made at a bulk, and accordingly, these were adjusted to the accounts. Now, my lord, we have indicated in our ledger accounts, this is only for our, my lord, convenience. The ledgers were maintained. These are not the documents which were indicated.
Your account will not give dominance to the fact that it can be filed over here. These are all arising out of separate invoices.
Separate purchase orders, my lord.
Then those separate purchase order, how does this give the jurisdiction to
No, my lord,
court?
this is only, my lord, if I may, subject to correction, my lord, only to avoid multiplicity of proceedings, and also, my lord, to avoid conflicting decisions by the different arbitrators, because the
Multiplicity of proceeding cannot give rise to jurisdiction.
absolutely, I bowed down, my lord. My jurisdiction is, your lordship, in respect of only, my lord, I'll just indicate to the purchase orders once.
You confine it only to that purchase order, which is for this quarter. The rest of it, you go and file it over there.
No, my lord, only this court has the jurisdiction. There's no
Jurisdiction for one purchase order problem.
all the purchase orders. I'll
Purchase
just
orders
indicate.
refer to, my lord, Kolkata as the venue of arbitration, my lord. All
Yes.
of them.
Same venue is same between the parties, your lordship. There's no difficulty in regards to that, your lordship.
What is the difficulty?
Only, my lord, I am only harping on the point that the conduct in respect of the payments were made between the parties. There's no, my lord, distinction that a certain amount of payment will be made in respect of the particular purchase order.
It's a running bill which is going.
This is a running account between the parties, my lord. So only in that regard, my lord, all I am humbling, since there is an arbitration clause, valid arbitration clause, and there's no dispute to that, your lordship. And in that aspect, only one and arbitrator may be appointed. That is only humbly praying.
The issue of limitation regarding even one of the bills. If the venue is Calcutta and only issue is regarding limitation, that some of the bills, the limitation starts running. That can be decided by the arbitrator.
I bow down, my lord.
Decided by the arbitrator, my lord. But this present application, my lord,
is not maintainable because I'll take your lordship to several orders of this court, my lord, thereby granting liberty to the petitioners as well as the respondent to disclose documents which will substantiate that the purchase orders are interlinked, intrinsically collected, and that a single arbitrator can be appointed to adjudicate the disputes. They have used the reply. They have subsequently used a supplementary affidavit. A reply has been filed, my lord. So, my lord, this question was already, my lord, put forward before the honorable court, and the honorable court said that show me the documents so that I can pass an order holding that these are connected. My lord, I will only take this in endeavor to show that the documents would themselves show that these are separate, my lord. My lord, that is all, my lord. My lord, your lordship will kindly first have a look at, my lord, the purchase order at Annexure 11 of the Section 11 application, which is dated.
Gopal, Section 11. Page.
My lord, 11 of the Section 11 application.
Page.
11, my lord. 11. My lord,
Annexure A.
This is Annexure A, my lord. My lord, Annexure A contains, my lord, your lordship will take a look. My lord, on the top right, it mentions site description. It mentions construction of buildings for IIT Bhubaneswar. My lord, on the top right, my lord, site description. Just below, my lord, date, indent number, contract number, site description is there.
Who are the directors of the company? Simplex?
Mr. Mundras, the Mundras are the directors, my lord. They are the promoter directors. I know your lordship had held in one matter of.
Yes, but that was because of.
I know Salarpuria.
Yes.
JV,
So they are not there in this.
There are joint ventures, my lord, Simplex and they, but not in this matter.
I have nothing to do with it.
Yes.
So Salarpuria is not
involved, my lord. My lord, page 11, my lord, mentions, my lord, the site for the purchase order as Bhubaneswar, Orissa, my lord. Your lordship will kindly take note of it on the right hand side towards the top, my lord. And my lord, page number 14 of the same document at the bottom shows that the weight of the plywood should be 34 kgs per sheet. I just showed this to show that the different purchase orders had different specifications with regard to the items as well. My lord, page 14, average weight 34. My lord,
where are you reading it? On page 14, average weight 34.
My lord, annex, page 14 says annex.
34 kg per sheet.
Yes, miss, it's 34 kg per sheet, my lord. And page number 16, the arbitration clause is at clause 23. Now, this I'll show is different with regard to the other and other as well, my lord. Here, the arbitration clause is clause number 23 at page 16. Similarly, my lord, your lordship will kindly have a look at page 17, which is the next purchase order. This refers to the site at
the first one, huh?
This was the first one. First one was with regard to a site in Bhubaneswar for 34 kgs of specification of plywood, and the arbitration clause is at clause 23. The second, my lord, purchase order is at page 17. This is with regard to Holdia, my lord. Holdia Indian Oil Corporation project, my lord. Project of IOCL, page 17. 17. Page 17. Earlier was IIT Bhubaneswar. This is Holdia Indian Oil Corporation. So the principal contractor there was IIT Bhubaneswar. Here it is IOCL and Holdia Refinery is the site project. So the principal employee is also different, my lord. And my lord, the specification of the plywood, your lordship will find at page 20. These refers to 23 to 24 kgs per sheet. The earlier was 34 kgs, my lord. Page 20 of the same document. And the arbitration clause is again at clause 23, page 21. Page 22, my lord, is an incomplete document with regard to a project at Uttarpara, Hooghly, with regard to construction of, my lord, Sriram Grand City. It's a residential project, my lord. With regard to Uttarpara, Hooghly, we do not have any arbitration clause here. I have taken this point in my opposition and then they have dealt with this point. My lord, thereafter, my lord,
The
kindly have,
third one, right?
this is the third one, HON'BLE, which doesn't have any annexures, my lord.
No, my lord, I'll just indicate once, if I may humbly interject, your lordship.
Let it finish.
There are
Well,
three, only to the point, my lord, 3 purchase order has been annexed in my section application, section 11 application, and the other 3 have been dealt with, my lord, in my reply.
So
He may indicate that, my lord, that has been some mistake in our part as well. In the reply, my lord, we have rectified that, my lordship.
Can't be done.
My lord, it's there, my lord,
Can't
because
in your reply, you can't.
no, my lord, what has happened, my lord? There was some discrepancy at the office, my lord, while filing of this, my lord.
I'm not going to consider that.
No, my lord, it's there in the reply, my lord. 3 purchase order have been dealt, your lordship.
As far as the prayer clause is concerned, can't be part of the reply.
My lord, will kindly pardon me with that, your lordship.
No, sorry, this can't be done. You withdraw it, you file a better petition with better particulars. This can't be done.
but thereafter, my lord,
I'm only dealing with these 3. Yes.
in fact,
Want to file a better petition with better particulars, you're most welcome to do it. But in this, I will not consider with your reply.
Well, it's there, my lord.
I'll
It's there, one of it a mistake, your lordship, on
I'll-
party, lordship.
give my findings to it. I will not consider. You want to withdraw, file a better petition with better particulars and probably think about what all you want to file also.
in fact, my lord, the document at page 35 is a single page document. There's nothing with regard to specifications,
No,
annexures.
we have dealt that in our reply, your lordship. It's there, my lord. All the 3 purchase orders, the remaining purchase orders are there in the reply. That's the only, my lord. If my lordship kindly shows mercy, my lord, upon us, your lordship.
Withdraw it, file a fresh one. I'll give you liberty to file. File a fresh section 11.
Very well, my lord. If
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file a better petition with better particulars.
no liberty bill.
The liberty as prayed for is granted. The present petition is dismissed as withdrawn.
Grateful, my lord. Lordship, in item 10, my lord, 10 to 14, my lord, Mr. Muhammad Tabriz is appearing on behalf of the petitioner. My lord, due to some personal difficulty, my lord, could not appear, my lord, either virtually or physically. And my lord directed me to request your lordship to kindly fix it up on 18 so that he personally can come and, my lord, argue the matter.
Is it an auspicious day?
My lord, 18, after 18, my lord, 18 to 20, as per the direction, my lord, I have received, my lord. If your lordship kindly,
We don't work on the directions of
my lord, I follow, my lord, about my big conditional
not
apology, my lord.
today, that's it.
Lordship, he will be appearing from Port Blair, my lord. If your lordship can,
Oh, Mr. Tabriz
Tabriz from Port Blair.
appear online.
My lord, if it is possible, my lord, to keep it on 18th.
Evening after 18th.
On 18th, my lord. 18th, he will come, my lord.
All right. Keep it on 18th.
Grateful, lordship.
No, time change. 19th. 19th.
19th.
But can be 20th, my lord.
Execution date.
As the lordship is 19th. 19th. Great. 14th.
Lordship, it is section 14 application.
And now 15th.
Lordship, it is section 14 application, twice time being granted, an extension made for opposition, no opposition filed, and they have communicated that the arbitrator is appointed since 1.5 years. So on Sunday, Lordship, arbitrator set his meeting, and I have communicated the entire thing. He communicated last day evening in my cell phone. He have refused, but I have not yet received the formal order. He have communicated me. I can communicate at the bench that he are not willing to continue. So, and since the application is pending from 16th February 2026, Lordship, I feel that they might have no objection in appointing new arbitrator because the entire process only been proceeded till adjudication of section 16 application, nothing.
Not only on the last occasion, the point that I had only with respect to the extension. Thereafter, the section 16 order has also been passed, and thereafter the minutes are also recorded. They have participated, and Millard extended the time for filing a rejoinder. So this is the status right now, and whatever Millard Bhatt's wish.
Lordship, may I?
He's saying that the arbitrator has refused.
Lordship, I have.
That I
Yes,
not
I
in
have
the
no.
minutes.
I have
Not in the,
in my cell phone.
there is no
Cell phone
official
will not do. You have
Yes,
to file a
Yes.
supplementary
So-
affidavit with the
Lordship, another thing, Lordship, the pleading not yet completed, so there was no requirement of any extension. Lordship, the learned arbitrator also communicated there was no requirement of any consent, although you have made that consent.
It is recorded, Millard, that
Yes,
the
yes.
claimant
It's a section 14 application.
Yes.
Right?
yes, section 14.
So if the arbitrator has resigned,
Millard, there is no official communication in the last minutes.
share
Speaking
the
on-
communication with
Yes,
him.
I have shown in my cell phone the
There is
communication.
not any
Just
official communication
I-
from the air.
yes.
Get an official communication, then come
Lordship,
back. Not
kind-
just wait.
Recusal, Millard, I cannot
Yes,
stand in
yes.
the way, of course.
Lordship, in that even 2 weeks adjournment because he is not
Take
well.
2 weeks.
কবে আবার দেবে আবার extend করে?
Learned counsel for the petitioner. Should I record that?
Lordship, yes, I have communicated. Yes.
Learned counsel for the petitioner states that the
I'm not taking cognizance of whatever he
No, no.
arbitrator
personal communication.
has
that-
resigned
Yes,
from the present
communicated
arbitration
by the applicant.
proceedings,
That can be recorded from the applicant. So one.
though
Yes. So one can.
no official communication has been received by him apart from a message on his cell phone. The said fact, learned counsel for the respondent states that he is not aware of any such communication. The parties pray for an adjournment of 2 weeks to ascertain the correct position and to place on record the communication of the learned arbitrator that he has resigned or he has terminated his mandate from the arbitral proceeding. He has resigned from the arbitral. Let a supplementary affidavit be filed. Learned counsel for the petitioner seeks and is granted 2 weeks' time to file a supplementary affidavit bringing on record the official communication of the learned arbitrator. Just after 3 weeks.
Deeply.
Sixteen.
Item number 16, I am for the respondent. The lordship was pleased to send the matter to the mediation.
Yes.
The matter has been settled, your lordship. Now the next date before the mediator is Friday, your lordship. We shall file the terms before the learned mediator, your lordship.
15 days time may be
For
given.
extension of time, so that the matter may be returnable up on 18th or 17th. whatever.
Learned counsel for the petitioner, well, learned counsel for the parties submit that the matter has been settled before the mediator. To arrive at the terms of the settlement, the matter is listed before the mediator on
Friday, your lordship. Day after
Seventh.
tomorrow.
on 7th.
Seventh.
On 7th of August 2026. They pray for an adjournment. Let this matter be listed. When do you want listed after?
A fortnight's time is sufficient.
After 2 weeks.
Deeply oppressed.
Seventeen.
Please,
For
Lordship,
the respondent.
my section 11 application, I am seeking leave to withdraw without any liberty before Mr. Naik starts opposing.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is discussed.
Grateful, my lords. Deeply obliged.
Deeply obliged.
You have given up.
I have given. Grateful, my lords.
Mr. Naik will run. I hope you run it nicely.
Yeah?
I hope he runs these are the duty free, right?
I am the duty free. Now it's shut down.
I'm the airport.
He is the airport. He chucked me out. I'm sorry for that colloquial term. Yes, the same matter which your lordships, they were pleased to disallow my writ. Now they've given it to somebody else. That new person hasn't come. So duty free, there's no duty now.
Nobody knew us, come.
Somebody's come, my lord. The tender matter, your lordship would recall.
Yes, there was
No, nobody has stepped in yet. They've given it
Physically,
to
but the
somebody.
tender has been awarded. Somebody else is in
So
the
how much
contract.
time will it take?
Possibly, my lord, I don't have the exact instruction, but they're in the process of taking over the premises.
Take
We
another
were there up
three-
until
three-
July. Now they're possibly clearing out
Another
the
5-6 months they'll take. That is what my client said.
If Mr. Thakkar and I ever take a flight, I will make sure I'll take it.
He has to take me. Grateful, man.
Deeply obliged.
18. Well, this is my application.
But before she starts, Millard, can she serve me a soft copy, Millard, and the matter may be kept on Monday? Monday or Friday?
But already served, Malad.
Yes,
This is
sir,
my
she
affidavit of
served.
service to the Malad.
Instructions are that it has not been served. Millard,
This is my
ready to
affidavit of
accept soft
service,
copy?
Malad. Malad, in the meantime, Malad, I will serve the soft copy, Malad, if your lordship can
She
fix.
need not print it.
Well, I don't have another spare copy, Malad. Then
No,
I'll
you can share the soft copy.
What is it? Section 11?
Section 11,
You're
Malad.
opposing it?
Millard, I'll have to see. That is why I'm saying that kindly keeps it on
Malad,
Monday. There's
I
no-
will just, then and then, Malad, I only just show the
there's
clause
no
of the.
to oppose Section 11, but still, if she can give.
The only thing, just check that whether you want 3-member.
Yes. Yes,
Get a-
that I'll also
get-
take instruction.
Yes, take instruction.
Depends on the quantum. How much is the quantum?
Quantum is more than 20.
What is the quantum?
Well, more than Malad, 20, Malad.
It will be better for one tribunal because too much fees will be.
So just decide if you want
Yes.
one or.
Lord, we'll come back, Lord, on Monday. Your lordship,
Affidavit of service taken on record. Learned counsel for the respondent states that he has not received copy of the petition.
26 lakhs.
The same is handed over to him. Let this matter be listed on Monday.
I thought she's saying 20 crores. The sum
No,
is
no, no.
26 lakhs.
26 lakh.
3 members, Lord.
You should have some
Party will
younger
go
member
into
of the bar.
insolvency. 26.
No, 26 lakh.
Wait.
Your Lordship, I'm for the petitioner, not this week, Your Lordship.
Why? What happened?
Your Lordship, the reply is not affirmed. The petitioner is a 73-year-old lady. He has gone some for medical emergency. Will be do. Your Lordship may fix it on any day on the next week.
Affidavit in opposition is taken on record. Reply, learned counsel for the petitioner seeks and is granted.
Any
How
on
much
next
time to
week.
file your reply?
Tomorrow it will be affirmed, Your Lordship.
Takes 1 week time to file his reply to the said affidavit in opposition. List after, when do you want?
Monday, Your Lordship, Monday, Tuesday, any. Next week, any time.
1 week you will take.
1 week, yes.
You will take to affirm or to file it after 2 weeks listed after.
Grateful, Your Lordship.
Okay. Next to next Monday, keep it next to next.
Next to next Monday.
Next week.
नाम तो दीजिए
20.
Lordship, this is my Section 11 application, Lordship. I'm being led by Mr. Chandiramani. He is appearing online, Lordship.
My lords, I'm appearing for the petitioner in this matter. My lords, on the last day occasion, your lordship had directed us to file an affidavit of service, my lords. Lord, this has been filed and the tracking report has been placed before you. However, my lords, there has been no appearance on the part of the defendants.
That's all right. Have you served them?
Yes, we have
Please, my
served
lord, we have served them multiple more than once, my lord.
Last time tracking report was not there.
Yes,
sir.
Lordship. Yes.
Yes.
So we have freshly prepared one.
What is it? Yes, tell me.
My lords, this is an application filed under Section 11 of the Arbitration Act, The disputes herein, my lord, arise out of a memorandum of agreement which is dated 21st December 2022, my lords. My lords, clause 32 at page 26 of this agreement basically brings out the arbitration clause, which requires, my lords, for both parties to appoint one arbitrator each, after which both of these arbitrators shall mutually appoint a third arbitrator for resolution of all disputes. My lord, pursuant to execution of this agreement, the parties had conducted business, after which there were certain amounts due, my lords, and these amounts total to about 29,28,105 rupees on the 31st of January 2026. My lords, in view of this, we had issued them a legal notice dated 10th December 2025, my lords. And my lords, however, to this my lords, to this legal notice, there has been no official response, my lords. However, there were other email responses which are produced at page 48 to 50, whereby first, my lords, initially they had informed us that they are willing to settle the matter and they required some time, and had asked us for some documents in that regard, which we had shared with them. My lords, after that, they had sought a ground of ill health and asked for some time, which also, my lord, we obliged. However, till date, there has been no response. Hence, we are before your lordships in this application.
Where's the arbitration clause?
My lords, clause 32 at page 26 of the petition, my lords.
Clause
32, Lordship.
2, my lords.
Page 26, Lordship. Last paragraph.
The 21 notice.
My lords, 21 notice is from page 38 onwards, my lord. Page 38 to 48.
There you go. The petitioner has filed the present application under section 11(6) of the Arbitration Conciliation Act, seeking constitution of an arbitral tribunal for adjudication of dispute arising out of the carrying and forwarding agreement, right? Agent
Please,
agreement.
please, my lords. Carrying and forwarding agent agreement.
Dated 12th October 2023. It is the case of the petition that the parties had initially entered into a memorandum of understanding, memorandum of agreement dated 21st day of December 2022, under which the petitioner was appointed as the carrying and forwarding agent of the respondent for the North Bengal region. Full stop. In terms of the agreement between the parties, the petitioner had deposited a sum of rupees 15 lakhs with the respondent. Subsequently, deposited security of rupees. Deposited security deposit of rupees. Subsequently, upon the respondent's request, the petitioner deposited further a sum of rupees 5 lakhs, taking the total security deposit to rupees 20 lakhs. Thereafter, the parties executed the carrying and forwarding agreement dated 12/10/2023, which superseded the earlier arrangement contained an arbitration clause in clause 32 thereof. Full stop. Learned counsel for the petitioner alleges that although the petitioner duly performed its obligation under the agreement, the respondent failed to refund the security deposit and further failed to make payment of commission, warehouse rent, office maintenance charges, and other amounts to be due and payable under the agreement. Full stop. According to the petitioner, a sum of rupees what is the balance?
My lords, as on 31st Jan 2026, it was 29,28,105 rupees.
2928,105. 105, right?
05
is due and payable remain outstanding to the petitioner as on 31/1/2026. Full stop. It appears from the record that the petitioner has invoked the arbitration agreement by issuing a notice under section 21 dated 10/12/2025. Full stop. By the said notice, the petitioner nominated Debjit, page 42, Debjit Mukherjee, advocate, as its nominee arbitrator, and called upon the respondent to appoint its nominee arbitrator in terms of the arbitration clause. Full stop. Though the respondent acknowledged the receipt of the said notice and sought time on more than one occasion, no nomination was made on behalf of the respondent. Full stop. Heard counsel for the petition and considered the material placed on record. The existence of the arbitration agreement contained in clause 32 of the carrying and forwarding agent agreement dated 12/10. The existence of the arbitration agreement contains a valid arbitration clause, i.e. 32 of the carrying and forwarding agent agreement dated 12/10/2023, and the same is not in dispute. Full stop. The correspondences exchanged between the parties and the notice invoking arbitration indicate that the dispute has arisen in connection with the said agreement. Full stop. Despite invocation of the arbitration clause, the respondent has failed to take any steps for appointment of its nominee arbitrator in accordance with the agreed procedure. Full stop. At this stage, the scope of examination under section 11 of the Act is confined to the existence of a valid arbitration agreement containing a valid arbitration clause. Full stop. Valid arbitration agreement. Full stop. This court is satisfied that a valid and enforceable arbitration agreement exists between the parties and the disputes have arisen out of the same, and the petitioner has raised, and the disputes are raised by the petitioner are covered by the said agreement. Full stop. In these circumstances, this court appoints
Shri Devjit Mukherjee. We have proposed the name of Mr.
appoints so and so as the nominee arbitrator on behalf of the respondent, full stop. The nominee arbitrator appointed by the petitioner, namely Shri Devjit Mukherjee, advocate, and the nominee arbitrator appointed by this court shall, within 2 weeks from the date of communication of this order, appoint a presiding arbitrator, full stop. Upon such appointment, the arbitral tribunal shall stand constituted and proceed to adjudicate the dispute and differences arising out of and in connection with the carrying and forwarding agreement dated 12th October 2023. Full stop. The learned arbitrator shall enter reference in due compliance with section 12 of the Act of the said Act. Full stop. He shall be entitled to fix his remuneration in terms of the board schedule of the Act or with the consent of the parties. All rights and contentions of the parties on the merit of their respective claims and defenses are left open for consideration by the arbitral tribunals. With the aforesaid direction, the present petition stands disposed. Affidavit of service is taken on record. Despite service, none appears for the respondent. Respondent or respondents? Only one, right?
Only one respondent.
Phone number.
How much is the claim amount?
Claiming amount is Lordship
29,28,100.
Want some younger member of the bar? Give another name. Somebody is there. We'll appoint him. What's your name? We'll appoint him. How many years? Madam, how many years you have put in? We'll appoint. Give your what's your name? Just give your
Phone number.
appoint so they are learned arbitrator on the update.
Lordship, this is my application under section 11, being led by Mr. Chandramani.
My lords, in this matter, the petitioner is same as serial number 20, my lords. However, the respondent was, my lords, here also there was a super distributor agreement that was entered into between the petitioner and the respondent.
Party?
My lord, parties are
petitioner,
different.
Lordship.
Petitioner is the same, my lord. Parties are different. The respondents differ. Lord, arbitration clause here is clause 36 at page 26 of the petition.
What kind of agreement is this?
My lord, this is a super distributor agreement whereby, my lords, the respondents were to provide goods to the petitioner who was to distribute these goods for sale, my lords, in the northwest regions of West Bengal.
Notice on the same date, 10th December.
Please, my lords, on the same date, legal notice has been issued. My lord, the difference is, my lords, in this matter, the respondent number 2, my lords, replied with a reply notice whereby he did not dispute the existence of an amount.
Where's the affidavit of service?
Lordship.
served?
It's been served.
Yes, what were you saying?
My lords, in this matter, we had received a reply notice to our legal notice from the respondent number 2, who is one of the partners of the respondent number 1 partnership firm.
Page?
My lord, this reply is annexure E, which is at page 44 to 48, my lords.
What does it say?
My lords, they have basically asked us for additional documents. That was one. And the second thing was, my lords, they had disputed the quantum of the claim and not the existence of any amounts payable under the agreement, my lords. My lords, surprisingly, the point to be highlighted here, my lords, is rather, despite making these statements in their reply notice, my lords, they have asked us to recall our Section 21 notice rather than appoint an arbitrator for adjudication of the disputes under these agreements, my lord.
All right, take up. The petition. It is a case of the petitioner that the respondent had appointed him as a super distributor for entire region of North Bengal or certain
Certain parts, my lord. The Uttar Dinaj
territories in North Bengal under the agreement dated 4/5/2023, pursuant to which the petitioner had invested a sum of rupees 16 lakhs, full stop. Thereafter, the parties entered into a memorandum of understanding dated 21/8/2023, forming part of the said agreement, full stop. Forming part of the said agreement, under which the petitioner invested a further sum of rupees 5 lakhs, taking the total investment to rupees 21 lakhs, full stop. According to the petitioner, despite repeated demands and reminders, the respondent had failed to honor their obligations under the agreement and the memorandum of understanding, including repayment of the amounts invested and other dues payable to the petitioner, giving rise to the dispute between the parties. Full stop. Clause 36 of the super distributor agreement contains an arbitration clause, providing that the dispute between the parties shall be referred to arbitration, and that in the absence of agreement on a sole arbitrator, each party shall appoint its own arbitrator, with the two arbitrators so appointed nominating a presiding arbitrator. Full stop. Learned counsel for the petitioner states that he invoked the arbitral proceedings by issuing a notice under section 21 of the said act dated 10th. This notice is 2nd January.
Lordship, that is the rejoinder that we are
Rejoinder.
That is the
10th December 2025. by issuing a notice December 2025, nominating Shri Devjit Mukherjee, advocate as nominee arbitrator, and calling upon the respondent to nominate their arbitrator. Full stop. While the respondent replied disputing the petitioner's claim, they did not, either within the stipulated period or thereafter, nominate an arbitrator on their behalf. Full stop. This court has heard the argument advanced by the learned counsel for the petition and has perused the material placed on record. Full stop. The existence of a valid arbitration agreement is not in dispute. Full stop. The correspondence between the parties, including the notice of invocation, shows that the dispute have arisen between them in connection with the said agreement and memorandum of understanding. Full stop. Notwithstanding invocation of the arbitration clause, the respondent have not nominated the arbitrator as required under the agreed procedure contained in the said agreement. Full stop. At this stage, this court's inquiry under Section 11 is confined to examining whether a valid arbitration agreement exists. Full stop. On the perusal of the record, this court is satisfied that a valid and enforceable arbitration agreement exists between the parties, and the disputes raised by the petitioner fall within its scope. Full stop. In these circumstances, this court appoints the same person, so and so, as the nominee arbitrator on behalf of the respondent for the same order.
Grateful.
How much is the quantum here?
40.45 lakhs.
My lord, 40 lakh 40,000. My lord. 40 lakh 45,318.
Grateful.
Grateful.
Now 22.
22 I will prepare for the respondent number 1.
Yes.
22 is my petition, my lord.
Out of respondent.
My lord, the dispute arose. There was a registered development agreement. And that registered development agreement, there are two agreements in fact. The first agreement was executed with only one person on 23rd August 2021. Lordship will find that at page 20 to 52.
Page
20 to 52. Subsequent to the execution of that agreement,
is the first development agreement.
that's the first development agreement.
Page
Now,
20.
yes, the development
Included in 2021.
my lord, 23rd August 2021.
Yes.
Thereafter, we are the partners of the partnership firm, the developer. And we discovered that there are other co-sharers and there is a partition suit pending in the trial court. Thereafter, at our instance, we got the dispute between the partners inter se settled. The co-sharers inter se settled. And then the second development agreement was executed with all the co-sharers. That is between page 73 to 110. Lordship will find that at page
73. 2022, right?
My lord, that was executed in 2022. The building construction has been completed.
Is the second agreement.
This is the second agreement. Both the agreements contain the arbitration clause. Now, the second agreement also has a reference to the first agreement. So, in my humble submission, the first agreement gets merged with the second agreement. We are at page 91, clause 5, where the reference of that is given. The first party has already gone through the earlier development agreement such and such, being such and such, wherefrom they knew that the first party shall have their allocation share along with the share of. So therefore, the second agreement refers to the first agreement. The parties are aware of the first agreement, and In my humble submission, the first agreement merges with the second agreement. Now, the dispute arose after the structure has come up. One of my partner, who is the respondent number 1 herein, in collusion with the developer, other co-sharers, started selling off the properties.
One of your partners.
One of my partner, the respondent number 1. My learned friend's client. And then, since there is a arbitration clause, we give a section 21 notice and we file a section 9 application before the learned trial court. We get an interim order. And now we are before Lordship for appointment of an arbitrator in terms of section 11 because they did not respond to section 21 at all. And
where is the arbitration clause? Page
my lord,
93.
a arbitration clause is at
93.
my lord.
Two arbitrators.
Two arbitrators, they did not agree. So now
Now you want one arbitrator?
Single arbitrator.
But I'm opposing this application.
Very good.
My lord.
Section 21.
Section 21 is page 139. Part 2, I think. 139.
All right. Why are you opposing the application?
My lord, my first submission is, my lord, it is outside the scope of arbitration. Why?
Outside.
Now, my lord, admittedly, my lord, I am one of the partner.
So go before the arbitrator.
Yes.
He'll
Now-
decide whether it's outside or not.
Yes. Now, what has happened, my lord? The section 21 notice and also this application, my lord, the partnership firm has not been made a party.
Partnership firm has not been made a
Partnership firm has not been made a party. My lord, his dispute is essentially against me.
Yes.
And that partnership agreement, my lord, is an unregistered agreement. I'll get the benefit of section 69 of the Partnership Act.
Not in arbitration.
Now, that's one point. And the other most important
All
part,
these points you can raise before the arbitrator.
difficulty is this, my lord. The firm has not been made a party in this instant proceeding. My lord, kindly takes his section 21 notice at page 42, 142.
Yes.
May I just read it for your lordship?
Yes.
In the meantime, my clients came to know that you formed a nexus, that is me, with one of the partners of my clients, that is addressee number 1. Addressee number 1 is me, and sold out flats to different persons by registered deed of sale. There are 23 flats that have been sold together with the entire ground floor comprising of such and such, and also have been sold to different persons, depriving my clients from getting their legitimate share. Practically, you, the owners of the property under development agreement addressee number 2 to 13, in connivance with one of the partners of my clients, that is addressee number 1, practically siphon my client's share of profits. Now, it's their share of profits that they are seeking. Now, this share of profits, my lord knows it's a partnership agreement. The basis of the partnership agreement is a share of profits. Now, he's essentially seeking that share of profits. Now, that share of profits, if he has to seek, the partnership firm has to be made a party, my lord, that he has not done. And he has deliberately not done because, my lord, that firm is unregistered in my respectful submission, 1. And 2, my lord, kindly takes the arbitration clause at page 93. If any dispute or difference which may arise between the parties, my lord, here the parties is, in my respectful submission, it's the partnership firm and the co-sharers, the landowners. Now, his entire grievance is against the partners, as I've read before. Therefore, my lord, the partnership firm is an essential party, and he ought to be served with a section 21 notice, and a section 11 ought to have been filed against the partnership firm, because his entire claim is against the partnership firm. Well, may I file an opposition to this, my lord, because I need to bring this fact, my lord.
So you are one of the partners of the partnership firm.
I am the two partners are before Lordship as petitioners. Two partners are before Lordship as petitioners against
the agreement with
one of my partners.
Just a minute.
my lord.
Development agreement which you got into with the firm?
Development agreement, unregistered firm. My name is also there as partners in the capacity of the partners of that particular firm. Lordship kindly sees the page 80. 80.
Yes.
Number 2, the developers shall mean jointly such and such, a partnership firm having office at such and such. Number 1, my learned friend's client, and number 2 and 3 are before lordships as the petitioners. Now, lordship, this is an unregistered partnership firm. The non-registration under section 69 of Partnership Act is not a bar so far as arbitration is concerned.
Sir, but then your right is only against the, not against one. You don't have a contract with one.
No, my lords kindly sees my section 21 notice.
Your relief is against the others, the co-owners.
My lord kindly sees my section 41 notice.
21.
Sorry, section 21 notice at page 141. This is addressed to all of them, all the co-sharers,
including your
my partner.
You don't have a contract with your partner.
Now kindly says, under instructions on behalf of my clients, I would like to inform 2 agreements for development such and such for the development of your property, that is the co-sharer's property, at this place in pursuance to the said development agreement executed 3 power of attorneys this in favor of my said clients and addressee number 1. Addressee number 1 is my partner.
But the unregistered partnership firm should be a party to the proceeding. They are the ones who have entered into the agreement.
Because unregistered, because it, in my humble submission, in section 9 also, partnership firm is not a party. Now, here in my humble submission, since it is unregistered, the partners in individual capacity can pursue their grievance.
Let them file their reply. The petitioner has preferred the present application under section so and so, seeking appointment of arbitral tribunal to adjudicate the dispute and differences that has arisen between the parties in terms of the. So second development agreement only, or we mentioned
second development agreement
in terms of the development agreement dated 11th July 2022. Full stop. It is the case of the petitioner that the respondent number 1 along with the co-owners of the said premises have illegally sold off flats affecting the right of the petitioner in terms of the development agreement. Full stop. Learned counsel for the respondent number 1 states that the present petition is not maintainable since the petitioner has not made the partnership firm who had entered into the development agreement dated so and so as a party to the present proceeding. He further states that no claim can be raised against him since there is no privity of contract leading to appointment of an arbitrator to adjudicate the dispute between the petitioner and him. Full stop. He seeks and is granted for 3 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. Learned counsel for the respondent number 2 and 4 seeks and is granted.
Respondent, my humble submission, respondent number 4 is not a signatory to any agreement.
File a reply. Respondent number 2 to 4 seeks and is granted.
2 and 4.
2 and 4 seeks and is granted 3 weeks time to file his affidavit in opposition. ऐसे करते हैं. Respondent number who 4?
2 and 4.
Who's not a signatory?
4.
Learned counsel for the respondent number 2 and 4 state that The respondent number 4 is not a signatory to the
Any agreement.
development agreement, and that no relief can be claimed against respondent number 4. He seeks and is granted 3 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. Yes. Who else are there? How many are there?
There are 13. I think affidavit of service has been filed on the last occasion.
All are served?
All are served. All are served.
Show me the affidavit of service.
ফেরত আসবে তো?
আগের দিন দিয়েছিল দেখো।
Three Sankari Kundu. Only 2 and 4.
4 is
All are
Parvati
your
Das.
relatives. All are your relatives.
2 and 4, my lord. And Geeta Das, I'm the landlady, my lord, and
My lord, 4 is 2's daughter. Kindly see 2, Vibha Das, wife of late
That's why
Ajit
he's
Das.
appearing for 2 and 4. That's why. But the rest are also your relatives.
Yes, yes, all are co-sharers.
Even,
So the
even
estate
third
is
one is your, this is wife. This is also your daughter. Sankari Kundu.
I've not received any instruction.
So Mera.
All are your relatives.
I'll have to seek for instructions of my client of objective. I have no instructions on appearing on behalf of anyone else other than response number 2.
Affidavit of service. Everyone served?
Yes.
No, not everyone has been served, sir. This is the problem. You want the court to look into all the service reports.
My lord, kindly says addressee absent for inquiry.
Addressee absent, how can he be served?
তারপরে কি হলো?
Who's this on page 15? Don't
Yes.
make the statement that all have been served.
No, no, my lord, it's my mistake. I ought to have been careful. This update is as on 11.
Sir, on page 15, one has not been served. On page 17, one is not served. Then page 19, not served.
If lordship permits, I can again.
Page 23, not served. How can you say everybody has been served, sir?
No, no, কোথায় সাপটা দেখাচ্ছে তো? Absent for inquiry.
You want me to do the exercise?
No, not at all, my lord. It's my mistake. It's my mistake. I ought to have been little careful. More careful, my lord.
Who are not served? Tell me. I'll come back. By the time, please see
I'll
and let me know.
that 15টা দেখ 15টা নাম্বার
Number of respondents who have not been served.
I'll do that.
Yes.
The 5 respondents who have not been served.
Give me the name.
Respond number 3.
Just take down the learned counsel for the petitioner states that seeks and is granted liberty to serve upon respond number
3.
3,
Respond number 6. Respond number 9.
9,
Respond number 12.
12,
And respond number 13.
30. Seeks and is granted further 2 weeks time to serve upon respond number 1. List after 3 weeks. 3 weeks time to serve. List after 6 weeks. After 5 weeks. 3, 1, 5. 5 weeks. Yes. Yes. The rest he'll serve. You file your affidavit.
Obligement.
You should have served everyone. Then I could have taken up the matter.
I should have.
It's my fault. I'm the advocate on record.
Let's do one thing. Let them do the service first. Then I'll pass directions to let the service be complete. Then I'll pass the direction. Strike down karo. So and so has been served. He seeks and is granted time to serve upon the rest of them. Keep after. How much time do you want for service?
2 weeks.
2 weeks. List after 3 weeks. Let the service be complete. Then we can.
My lord, item 23.
23.
I appear for the petitioner. Yeah, my lord, we were given a military engineering services construction contract under a tender floated by the respondent. We commenced the work as expected. My lord, there were hindrances at the work site. Drawings were not given, due to which there was delay. 11 time extensions were given by the respondent. There were 2 earlier cancellations which were revoked. Finally, my lord, the contract was revoked in March 2025. Now, under the GCC, which governs this nature of contract, my lord, there is a dispute resolution board that one can approach. We approach that under clause 71 of the GCC. The dispute resolution board consists of members of the respondent, officers of the respondent. DRB gave an order in their favor, in the respondent's favor. And now, my lord, we've invoked clause 70, which is the arbitration clause of the GCC, and now we are before my lord. We've given the section 21 notice, and the reply that they have given, the only ground that they've taken is that there is a clause which says that within 30 days of the DRB's order, the dispute resolution board's order, one has to give objection. We should have given an objection within 30 days. But my humble submission, and so therefore, since we didn't do that, it is barred by limitation. So, my humble submission is that, as far as limitation is concerned, that has to be looked into by the arbitral tribunal. And also, section 28B of the Contract Act says that any agreement which restricts a party's right to approach to initiate legal proceedings is void. So, these are my 2 submissions under which, and clause 70.
Show me the agreement.
The agreement is at page 49, clause 70.
Starts from. This is an
The
agreement for.
GCC starts at page 24. And clause 70, which is the arbitration clause, is at page 49. Back up. Back up. The next page has the clause 71, which is the dispute resolution board clause, which we invoked first. And the last line says, in case of disagreement with the decision of such DRB or conciliator, any party may invoke arbitration clause.
There's the time period.
No, Milan, there's no time period in this clause. They are saying that there is a 30-day period within which we have to give an objection.
We are not saying, my lord. We are not saying. They are well aware of this fact.
Where is it?
Will I start, my lord?
Oh, let me hear. Yes. And then you're 21.
Section 21 notice is at page 85. where we lay out the entire agreement, the nature of work that was given to us. And as far as the DRB is concerned, my lord, is at page 88 of the section 21 notice. Section 21. And their reply is at page 94. When the DRB process was going on, we have anyways objected to the functioning of the DRB.
Where is it? Where have they raised the objection?
My lord?
Where have they raised the objection?
Page 94, their reply to the section 21 notice, 22nd June 2026.
Anything else?
No, my lord. And my lord, we have some judgments which we would like to refer to, my lord, on, first of all, the Supreme Court judgment of ASAP Fluids, which says, as far as the Section 11 court is concerned, only the existence of the agreement has to be looked into, and even issues of limitation has to be decided by the arbitral tribunal, my lord.
He's not questioning the limitation. He's saying it's not maintainable.
Yes, my lord.
He's saying that within 30 days, we should have objected.
Yes, and that's why it's not maintainable.
Yes. So according to us, this is a issue, a limitation issue, which they are saying that we did not raise the objection. Very well, my lord. If that is not relevant, my lord, the other judgment which we would like to refer to is of Delhi High
I'm
Court.
not saying it's not relevant, madam. I'm just saying that the issue which they are
Yes.
trying to raise, it's not maintainable. Since
Yes,
you have
my lord.
failed to exercise your rights within
So
30 days.
we would rely on section 28B of the Contract Act.
Yes.
Which says, my lord, if I may play Contract Act, does my lord? My lord, para 8 onward of this judgment. Para 8, my lord, at page 3. Respondent does not dispute the existence of an arbitration agreement between the parties and in fact relies on clause 25 of GCC as modified, which is the arbitration clause for settlement of disputes. The singular objection to the appointment of the arbitrator is that petitioner did not invoke the arbitration agreement within a period of 30 days from the receipt of the decision of the DRC as envisaged in the clause, which according to learned counsel for the respondent extinguishes the right of the petitioner to claim its outstanding dues and remedy to take recourse to arbitration proceedings. Para 9. The question that arises for consideration before this court is whether the period for invoking arbitration can be restricted to a period less than provided under the Limitation Act 1963. This question need not detain this court as this issue is no longer res integra. In Grasim Industries Limited versus State of Kerala, we are also carrying that judgment. Dealing with a similar issue where the respondent declined to refer the matter to arbitration on the ground that the appellant had not invoked arbitration within the time stipulated in the arbitration agreement. Referring to section 28B of the 1872 Act, the Supreme Court held that the said provision unequivocally provides that an agreement which extinguishes the right of a party on expiry of the specified period would be void, and therefore, even if a restricted period for raising an arbitral dispute is provided for, the same would be treated as void. To the same effect is the decision of this court in National Highways Authority of India versus Mecon GEA Energy Systems. I'm not placing what has been held in Mecon. Para number 10. The same view was taken by this court in Shanti Prakash Goenka versus Mahanagar Telephone Nigam Limited, which dealing with an arbitration clause providing for a period of 90 days for invocation of the arbitration clause. The only objection of the respondent was the invocation by the petitioner beyond the stipulated period, and negating this contention, court allowed the petition under section 11.5 of the Act and appointed the arbitrator. The relevant passages are set out. Now, my lord, para 11. In this context, I may also refer to a recent judgment in GS Express, my lord, we are carrying that, where relying on the aforesaid judgments, this court appointed the arbitrator holding that clause 7.3.1 of the contract, to the extent it limited the period for invoking arbitration to 6 months, was unconscionable and void in light of Section 28B of the 1872 Act. In light of these judgments, this court is unable to agree with the learned counsel for the respondent that petitioner is precluded from invoking the arbitration clause only because it failed to seek invocation within a period of 30 days from the date of receipt of the decision of the DRC. Accordingly, I hold that the penultimate subparagraph of clause 25, which reads, if the dispute redressal committee fails to give his decision within the aforesaid period, or any party is dissatisfied with the decision of the dispute resolution committee, then either party may, within a period of 30 days from the receipt of the decision of the dispute redressal committee, give notice to the chief engineer for appointment of an arbitrator on prescribed pro forma as per appendix such and such. My lord, we are carrying the Supreme Court judgment also, my lord, we'll hand that over. Grasim. My lord, para 9 to 13. My lord, if I may place paragraph 9, it is at page 268. Having
Internal page 4.
internal page 4. Having perused clause 9 of the supplementary agreement dated such and such, we are of the view that the interpretation placed by the High Court on clause 16 was wholly misconceived. The aforesaid clause did not postulate the period within which a claim could have been raised by the parties to the contractual agreements. Even otherwise, we are of the view that in terms of clause section 28 of the Contract Act 1872, such a stipulation in a contractual obligation would not be valid and binding. Paragraph 10, Malat, sets out section 28. We are relying on 28B. Malat, agreements in restraint of legal proceedings void. Every agreement, now clause B, subsection B, which extinguishes the rights of any party thereto or discharges any party thereto from any liability under or in respect of any contract on the expiry of a specified period so as to restrict any party from enforcing his rights is void to that extent. Now, paragraph 11, Manoj. Section 28B unequivocally provides that an agreement which extinguishes the right of a party on the expiry of a specified period would be void. Therefore, even if a restricted period for raising an arbitral dispute had actually been provided for, the same would have to be treated as void. Paragraph 12. In view of the legal position expressed herein above, the limitation with reference to the claim raised by the appellant, such and such, would have to be determined only under Article 137 of the Limitation Act. Well, this is what I would place. And well, the other judgment of 2023 GS Express Private Limited. Paragraph 6 to 11. Internal page 4. Heard, the facts are on. I won't place the facts, my lord. At paragraph 7, 8, and 9, certain earlier judgments of the Delhi High Court are referred to, and the Grasim Industries Limited also, my lord, of the Supreme Court. Then at para 11, thus, in view of the law laid down in such and such, there is no doubt to hold that invoking arbitration clause after 120 days would not waive the right of the petitioner to approach this court under Section 11 of the Arbitration and Conciliation Act. Hence, such petition is allowed and the arbitrator was appointed. Well, these are my submissions in view of... And well, this is a right prescribed by statute, and that cannot be curtailed by way of a clause in a contract, my lord. So, on that ground, my lord, we are invoking the arbitration clause.
Yes.
Lord, if your lordship kindly come to page 11, my lord. They have specifically suppressed this fact that they do not know about this clause. If your lordship kindly come to page 2.
It doesn't matter, sir. The law is well settled. What
My lord, but
are you
they
disputing?
have not annexed the whole agreement, my lord. Only a partial of the contract has been annexed over it by suppressing the rest of the agreement which they are signed over there.
Are you disputing the arbitration clause in the agreement? Whether they have annexed, they have not annexed?
No, I am not disputing on that, my lord. The only fact is that when they are knowing this fact,
The
46.16,
limited argument, what you started with, is on the basis that they have failed to approach
within the 30 days.
That is settled. That no longer holds any ground. All right. So now tell me anything else which you have.
So, Lordship, kindly allow me to submit that full contract before Lordship.
For what?
Because
Are you disputing?
No, I'm not disputing that.
Then?
I'm not disputing
For
that.
what?
But overall, my lord, they have said that.
Rather you take instruction, whether you want an arbitrator to be appointed or not, take instruction and come back. Otherwise, I'll appoint it. I have no problem in appointing an
Kindly
arbitrator.
give me 2 weeks time in the meantime so that
I will not give you 2 weeks.
Because
Last time also they sought time.
My lord,
29 July.
documents is lying in Patna, my lord. That is
That's
the
all
only
right.
part.
I'm not concerned.
My lord, they have
You
to
have
carry out the whole file from there, my lord. That is.
You don't need the file, sir. You need instruction. There is no need for the file.
Then I'll give it to you next Wednesday, my lord. Then
Take instruction. Next Wednesday.
Great.
Ago.
Lord, would kindly record that in that order that they will seek instruction. Lord. Otherwise, last time also they sought in time for taking instruction.
Petitioner has filed the present petition under Section 11(6) of the Arbitration and Conciliation Act, seeking appointment of an independent arbitrator to adjudicate the dispute arising out of the statement file. देखा ना?
The headquarters is at Baligan Maidan camp.
The files are lying in Patna.
Where's the what is the agreement dated? What is the agreement? Arising out of the agreement number? Where's the agreement number?
Agreement. They floated the tender on 30th December 2017. And the acceptance was on 16th March 2018.
Of 2017-18, executed between the parties in respect of the work relating to provision.
Malad wants the contract number.
Provision of OTN ACCN at Behrampur. Inverted comma close, full stop. It's on page 18. Learned counsel for the petitioner states that the petitioner was engaged in the business of manufacturing and executing of engineering work relating to windows and allied infrastructure. Full stop. Pursuant to an online tender floated by the respondent, the petitioner's bid was accepted and a letter of intent was issued in favor of the petitioner on 7th March 2018. Full stop. Thereafter, the parties had entered into the aforesaid agreement incorporating the general conditions of contract bracket में करना IAFW 2249 bracket close, which contains an arbitration clause under clause 70
of the GCC general conditions.
Clause 70. Full stop. Learned counsel for the respondent seeks time to take instruction as to the appointment of the arbitrator with the consent of the department, since the agreement is not under dispute. List after one.
For their claim. Great.
My lord, I beg to appear on behalf of the petitioner, my lord. I'm grateful that my lord permitted me to come back here to do the matter physically. I'll try to satisfy your lordship that section 21 notice is not faulty. Now, my lord, in this matter, my lord has already been pleased to look at the arbitration agreement. He thinks that all page 36, all disputes sole arbitrator, and the seat and venue is in Kolkata. Now, in the light of that, as my learned friend has pointed out before your lordship, and my lord was not happy with the language that has been used by us in section 21 notice.
Yes.
Now, if your lordship kindly allow me to place section 21 before your lordship wants. Well, may I place section 21? Unless otherwise agreed by the parties, the arbitral proceedings in respect of a party.
Where are you reading, sir?
My lord, I'm sorry, my lord, section 21. I'm sorry, my lord.
Yes.
My lord, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for dispute to be referred to arbitration is received by respondent. Now, my lord, here the notice is issued under section 21 notice. Better, my lord, may I come to section 21 notice once and show a few paragraphs from that notice. Starts at page 53 of my application. Now, my lord may be pleased to keep up to paragraph 8. Paragraph 9, kindly come to page 58. Paragraph 9 starts to 12, paragraph 9 to 12 provides for cause of arbitration. Why do I require arbitration? However, my client was shocked and surprised to receive that the termination notice of such and such, which states about the fact that team's original contract, which was awarded to you the noticing by the government, would cancelled and terminated by the government. Hence, the said termination letter dated 14th March 2026 was issued to my client, which is absolutely illegal, arbitrary, and has no legs to stand. The purchase order and its terms are conditions strictly govern the arbitration agreement. The agreement between my client and you, the notices, which the parties to the said purchase order are under the obligation to adhere to the terms and conditions and are bound by the same. That for any delay on the part of the successful execution of the project in terms of the aforesaid purchase order mentioned in the subject above, the penalty clause come into effect, and the same shall be applicable for the delay, subject to delay not being attributable to my client, which you, the noticee, are well aware. That my client has already put in huge sum of money for this project and has deployed adequate manpower and has purchased raw materials as per the terms of the purchase order. For such, no polyhouses to be installed and maintained. However, your sudden termination of the said purchase order has come as a serious shock to my client, as the work is being executed by my client within the time as informed to you and the government time and again. Thereby, such arbitrary and illegal termination of the said purchase order is putting severe financial hardships on my client to continue with the work further after the said illegal termination. Para 11, that my client, being the subcontractor in the said project, faced lots of difficulties to proceed with the execution of the said work and was put to heavy financial losses for frequent modification of re-alteration of the drawing and designs and specifications by you, noticee, as well as DHFPU, that is the government, for which there was delay in the execution of the project work, and because of such delay, there was cost escalation for the work in terms of the purchase order. 12. That due to interstate disputes between you, the noticee, and the DHFPU, it seems that it is well conspired and collusive decision between you, the noticee, and DHFPU to terminate the main agreement to oust my client and give the work to some other entity which is doing the same type of work for other region in Uttarakhand, and the said entity engaged in executing the same type of works for the other region has not achieved even 25% of the target of the project which my client has achieved till now in the present project as per the purchase order under subject above. So paragraph 9 to 12 gives the cause for arbitration, why that is my allegation.
Now, my lord, paragraph 13 and 14, why I felt necessary to invoke. Paragraph 13, my lord. It is stated that since the arbitration clause mentioned in the purchase order under the subject above expressly provides for agreement to settlement of dispute and appointment of arbitrator, which shall be in accordance with the Arbitration Conciliation Act, therefore we believe that it is manifest upon the parties that invocation of notice of arbitration for appointment of arbitrator must be guided by the principles enshrined in the Act, that is the independence and impartiality. My lord, pausing here for a moment, I had to say that because they had the right of unilateral appointment, but in the present law of the land, my lord, it has to be impartial and independent. Now, my lord, paragraph 14. Here that portion is there. Therefore, in terms of the arbitration clause mentioned in the said purchase order, which is duly signed and accepted and acknowledged agreement between the parties to the said purchase order dated such and such, the dispute now has to be settled as per the arbitration clause of the said purchase order agreement, and hence the same shall be settled as per the Arbitration and Conciliation Act, with the venue or seat of the arbitration proceedings to be held at Dehradun as per the address mentioned in the said purchase order dated such and such, to be the address of you notice at Uttarakhand and not in Kolkata. Now, here when my lord was pleased to look at this portion, my lord was pleased to form an prima facie opinion that my section 21 notice is faulty. Now, subject to correction by your lordship, my lord, my understanding that this is an offer. Why I say so? This is an offer to the venue. Why I say so? If your lordship then kindly permits me to read the subparagraph, it ought to have been paragraph 15, but I am reading as subparagraph to paragraph 14. Is my lord
Page?
I'm sorry, my lord, page 61.
Yes.
Now, towards the end of that portion, my lord, paragraph 14, my lord has been pleased to take note of, even on the last occasion. Now, page 61, my lord. That subparagraph. In view of the above, my client is entitled to receive. Now, he is depicting his claims. 1. All payments, including but not limited to towards all works performed by my client under the said purchase order dated such and such. 2. Any other sum due in terms of the said purchase order or agreement. 3. Refund of all valuable securities entrusted to you the noticee, if any. And 4. Other charges. 5. As well as compensation damages towards the losses incurred by my client as a result of your illegal acts resulting into the issuance of the termination notice dated such and such by you noticee to my client. So I have depicted my claims, not assessed. Then, my lord, kindly take the next sentence that is extremely vital. Client. For this purpose, my client is here.
Yes.
My client is invoking the dispute resolution mechanism under the above purchase order dated such and such, that is by the process of arbitration, in order to resolve all the grievances of my clients existing today in relation to the said terms and conditions as per the said purchase order agreed upon between my client and you the noticee. My client also reserves its right to claim other amounts that may become due or payable to my client from your noticee dated under the terms and conditions of the purchase order mentioned in the subject above. So, my lord, in paragraph, if I take paragraph 14 and that subparagraph and read it conjointly, my understanding, subject to correction by your lordship, that paragraph 14, where I say that arbitration ought to take place in terms of the Arbitration and Conciliation Act, and that be held in Dehradun, not in Kolkata, that's an offer. Had I had stopped there and would not have invoked the arbitration clause separately once again at the bottom, my lord, then I would not have any argument before your lordship today. In that light, My lord, the first portion that which troubled your lordship on the even on the last occasion, that is the offer. I say that the arbitration be held in Dehradun, Uttarakhand, not in Kolkata. But here, my lord, I invoke the arbitration clause ultimately at the bottom. Now, if your lordship kindly permits me to place paragraph 25 to 28 of my application once. Page 13, my lord, page 13 bottom.
So the contract is entered between
Lordship, the contract is entered between
Precision
I am a contractor, empaneled contractor to the state of Uttarakhand. The contract is to build poly houses for farmers in the state of Uttarakhand, your lordship. Lordship, my learned friend's client is a subcontractor to me. Now, my lord, my point of contention is twofold. Lordship, firstly, there is a negative averment that this court does not have jurisdiction to enter into the arbitral reference. So my lord does not have jurisdiction under section 11. That is my learned senior's case, not my case. Lordship, I have shown your lordship a judgment of a recent judgment of the Supreme Court of 2025, where my lord, the Supreme Court has laid down the functions of a notice under section 21. Lordship, specifically the jurisdiction of the referral court has to be is one of the functions of the notice under section 21. And my lord, the claims are not justified in the said notice at all. They have said, I have spent huge sums and I am entitled to my reliefs under the contract. That I will decide at the time of arbitration.
of contract between him and
Between him and the government, there is no privity of contract. And my lord, serious allegations of collusions between me and the state government to oust him from the scheme of things. My lord, if that is so, then my lord, he is hitting upon rights affecting the public at large. That dispute would not be arbitrable at all. Then I have to bring in a separate line of judgments if my learned senior is trying to argue on paragraph 12 of the section 21 notice.
well, he doesn't have a contract with
No, he does not. He does not.
I have contract with the respondent.
Yes.
They were awarded for the entire
Where's that contract with the respondent?
my contract with the respondent. My lord, that starts at page 33.
Your lordship.
Page 30.
Yes. This is the purchase order drafted by them, and I agreed to that.
If I can show your lordship para 21 of my lord senior's petition as well, if I may read
I'll place.
Let him place this.
The petitioner states that by its communication.
Let him place.
Lordship. Para 21.
My lord, after your lordship,
Where's the arbitration clause?
my lord, arbitration clause is there at page 36. May I place, my lord? Fourth bullet. First, second, third, fourth, fifth bullet. I'm sorry. All questions, disputes, or difference whatsoever shall arise between BCL or BCL's customer and you upon in relation to or in connection with the contract either may forthwith give the notice in writing or of the existence of such question or dispute or difference, and the same shall be referred to adjudication of sole arbitrator. CMD BCL shall have the right and authority to appoint arbitrator who is not connected with either party of the way. The parties to the dispute will share equally the cost of arbitration as intimated by the arbitrator. Such a reference submitted to the arbitrator shall be deemed to be the submission of the arbitrator within the meaning of Arbitration Conciliation Act, statutory modification thereof. The proceeding of arbitration shall be held in Kolkata. Then, my lord, the next bullet, jurisdiction clause, any legal dispute that may arise will be settled within the jurisdiction of Court of Kolkata.
Lordship, I do not dispute that.
Now, my lord, let us not argue piecemeal. Let me. Now, my lord, in the light of that, if your lordship kindly be pleased to come to paragraph 25 to 28 of my application. It starts at page 13, my lord, 1-3.
Yes.
Paragraph 25. The petitioner states that the said purchase order, which had been treated to be the contract between the parties, had been issued by the respondent from its registered office at Kolkata, thereby part of cause of action arose in Kolkata, that is within the jurisdiction of this honorable court. Further, the said purchase order also provides for a forum selection clause. Then I set out the jurisdiction clause, that is at Kolkata. Paragraph 26. The venue and seat of arbitration proceeding was also decided to be held in Kolkata. 27. The petitioner states that the entire underlying disputes between the parties were commercial in nature. The value of the subject contract was rupees such and such, 104 crores. The petitioner has assessed its claim of the arbitration proceeding will be much exceeding than rupees 30 lakhs, being the specified value. 28. Thus, issues raised in the present proceeding be tried, determined, and adjudicated by this honorable court, and that too in the commercial division. That is my pleading before your lordship, that the section 11 cannot lie anywhere except before your lordship. Now your lord. Now, my lord, your lordship is aware that while issuing a section 21 notice, being excited and adventurous, we draft it like a petition, and we here also we have drafted 10 pages notice, etc. Now, although we have invoked the arbitration clause correctly at the bottom of the notice, which is extremely vital for a section 21 notice, but at the same time, we have also given them an offer to hold the arbitration in Dehradun. There was no reply. There was no reply to section 21 notice.
No, that's not
so that offer goes.
That is not how it is. Sorry, this is your interpretation. I think very clearly you have invoked the arbitration clause and said that the venue and seat of arbitration is at Dehradun, as per the address mentioned in the purchase order, to be the address of you notice at Uttarakhand and not in Calcutta.
Now, my lord,
so your section 21 is definitely faulty for no reason but your fault. It's just an oversight and nothing.
My lord, I
had understanding of your.
My lord, I'll accept. Kindly allow me. Kindly, my lord has been pleased to bear with me for so long. Another 5 minutes, my lord. Had I stopped there, as I tried to satisfy your lordship, had I have stopped there, then it would have definitely faulty. But if you, since your lordship has also been pleased to take note of the second sentence after that, after this portion.
Yeah, invoking notice. Where have you stated? Where?
No, I have not stated anywhere. I have stated
we are not disputing that you are not invoking it, but the facts are absolutely wrong, contrary to your understanding and contrary to the contract.
My lord, I have stated that I am invoking in terms of the purchase order.
All right. So
for my satisfaction, once again, kindly look into that second sentence. Then I will not trouble your lordship with
regard to the document. The last line, invoking the dispute resolution mechanism under the above said purchase order dated so and so by the process of arbitration, in order to resolve all the grievances of my client
existing today in
relation to the set terms and conditions.
Yes. So, in terms of the purchase order, there I have not added any rider. The penultimate sentence, I have not added any rider. Now, your lordship is aware.
You want to issue another section 21, or you want me to decide this issue?
My lord, we are all creature of instruction. Your lordship is aware. Now, if your lordship is much more aware than me, that judgment of Bhagirathi Engineering. Citation বলে দিচ্ছি ওদেরকে দিয়ে দাও সফট কপি গুলো
You appear for BCL, huh? You're appearing for BCL.
I'm appearing for BCL.
My lord, Bhagirathi Engineering, Justice by Justice Pardiwala. My lord, my lord, this proceeding arose out of a Section 34 application. The award was initially set aside since the claims beyond Section 21 notice were allowed. Now, if your lordship kindly be pleased to come to paragraph 16 of the judgment. If I may. পরেরটা বের করে রাখো অধ্যায় Paragraph 16 of that judgment, my lord, if I may place. Secondly, the object of
Where are you? 16 is page?
my lord, internal page, page 11. Page number is there at the bottom, my lord.
Yes.
Well, secondly, the object of Section 21 of the Arbitration and Conciliation Act is only for the purpose of commencement of arbitration proceeding, is also well settled. Section 21 is concerned only with determining the commencement of the dispute or for the purpose of reckoning limitation. There is no mandatory prerequisite for issuance of a Section 21 notice prior to the commencement of arbitration. Issuance of a Section 21 notice may come to the aid of the parties and the arbitrator in determining the limitation for the claim. Failure to issue a Section 21 notice would not be fatal to a party in arbitration if the claim is otherwise valid and disputes arbitrable. So, my lord, here the existence of the agreement is not disputed. Here, whether I have got claims or whether those claims are arbitrable, those may be decided by the learned arbitrator. Here, it is not, at least not at all prima facie barred by limitation. Only thing, I have written something more. Whether now, my lord, the test before your lordship, whether only for that purpose, my lord will be pleased to entertain and allow my Section 11. And particularly when in Section 11 application, I have categorically pleaded why I have to come before your lordship only and not anywhere else.
Lordship, if I may indicate.
Now, let him finish. Another two more judgments, my lord. Another is 2025 volume 9 SCC page 686. My lord, here my lord may be pleased to find out the issue at paragraph 1, that is 696. Paragraph 1 starts at 696. Leave granted. The issues arising in the present appeal are whether the service of notice invoking arbitration under Section 21 of the Arbitration and Conciliation Act on a person or joinder of such person in the application under Section 11 of the appointment of arbitrator are prerequisites for an arbitral tribunal to exercise jurisdiction over him. And further, when can an arbitral tribunal implead a person to the arbitration proceeding? Here, my lord, what happened? Arbitration proceeding initiated, and in the midst, an application was filed before the learned arbitrator to implead another person. Point was taken for the third person, no separate Section 21 notice was issued, so the award was faulty. Now, my lord,
Yes.
Paragraph 29. That is at page 703.
Yes.
Page 703, paragraph 29. It is also relevant to note that while deciding such an application under Section 11(6) of the High Court or this court, as the case may be, undertakes a limited examination as per Section 11(6)(a). The court's jurisdiction.
Let me come back up.
I'm thankful that your lordship permitted me to at least
Yes, why not?
Yes. Yes. I stopped while citing paragraph 29 of that observer judgment at page 703. Yes. It is also relevant to note that while deciding such an application under section 11.6 of the 11.6, the High Court or this court, as the case may be, undertakes a limited examination as per section 11.6a. The court's jurisdiction is confined to a prima facie examination without conducting a mini trial or laborious or contested inquiry into the existence of the arbitration agreement, that is, whether there exists a contract to refer the disputes that have arisen between the parties to arbitration. Further, any examination into the validity of the arbitration agreement must be restricted to the requirements of formal validity, that is, whether the requirements of a written agreement under Section 7 of the Arbitration and Conciliation Act is satisfied. Now, my lord, I am for paragraph 29, I am relying up to this. Then, my lord, paragraph 46. At page 709. While we agree to the decision of Alupro insofar as holding that the notice under section 21 is mandatory, unless the contract provides otherwise, we do not agree with the conclusion that non-service of such notice on a party nullifies the arbitral tribunal's jurisdiction over him. The purpose of section 21 notice is clear. By fixing the date of commencement of arbitration, it enables the calculation of limitation, and it is necessary precondition for filing an application under Section 11 of the Arbitration and Conciliation Act. The other purposes served by such notice of informing the respondent about the claims after giving the respondent an opportunity to admit and contest claims and raise counterclaims and to object to proposed arbitrators are only incidental and secondary. We have already held that the contents of the notice do not restrict the claims, and any objections regarding limitations and maintainability can be raised before the arbitral tribunal. And the Arbitration and Conciliation Act provides mechanism for challenging the appointment of arbitrators on various grounds. Hence, while a Section 21 notice may perform these functions, it is not the primary or only mechanism envisaged by the Arbitration and Conciliation Act. Then, my lord, paragraph 60 at page 714, the summary. 60. Towards the bottom, my lord. Our legal analysis of the issues that we set out above, as well as our findings in the facts of the given appeal, can be stated as follows. A notice 60.1. A notice invoking arbitration under Section 21 of the Act is mandatory as it fixes the date of commencement of arbitration, which is essential for determining the limitation period and the applicable law. And it is prerequisite to filing an application under Section 11. However, merely because such a notice was not issued to certain persons who are parties to the arbitration agreement does not denude the arbitral tribunal of its jurisdiction to implicate them as parties during the arbitration proceeding. Then, my lord, 60.2. Next page. The purpose of an application under Section 11 is for the court to appoint an arbitrator so as to enable the dispute resolution through arbitration when the appointment procedure in the agreement fails. The court only undertakes a limited and prima facie examination into the existence of the arbitration agreement and its parties at this stage. Hence, merely because a court does not refer a certain party to arbitration in its order does not denude the jurisdiction of the arbitral tribunal from impleading them during.
Relevant for you. Not relevant.
Not relevant to me. Absolutely. Now, in fact, I should have stopped in the first sentence of this paragraph only. Now, I had the opportunity in appearing before your lordship in a few matters, and I know my lord's view that my lord's in fact doesn't entertain if I raise dispute with regard to a Section 11 in ABCD scope. My lord directs us to point out categorically whether you are disputing the existence of the arbitration agreement or not. limitation. In fact, that Chandra Shah case, I know what I have to face there. Now, here, existence not disputed. The arbitration agreement says three things: all dispute, sole arbitrator, Kolkata. Not disputed. I have categorically stated in my section 11 that for one, part of cause of action has arisen here.
There is no doubt.
No doubt.
About your section 11.
Now, section
What
21.
The only issue which pertains to or which is relevant for this purpose, adjudication of this matter, is your 20.
Absolutely.
Whether the notice has been properly given up.
Now, I'm grateful, my lord. Now, the notice, while I say that I am invoking penultimate sentence, no extra word has been added. While I say that
extra word has been
penultimate paragraph. Penultimate paragraph, my lord.
Relying on the last few lines of that.
Yes.
What about the first?
Yes, now my next sentence would have been that. Now, before that, while I say that why arbitration is necessary, there I say that that is why invocation.
What facts in your 21 notice, sir?
My lord is ever.
Can you factually make a 21 notice absolutely wrong? I mean, your venue mentioned is wrong, your place mentioned is wrong, and still you rely on your 21 notice. I'll set it aside. Well, I have to give you liberty. Otherwise, if you honestly ask me, I will not even give you liberty for wasting my time.
I know my
you should have easily, and this is not like limitation is running out. I can understand you are arguing so vociferously. If limitation was going out, you were, delayed. This is 27th March. You can easily withdraw it and issue a fresh 21 and come back to me. But you have pressed it hard. You have argued it. So dismiss with cost.
Cost, my lord.
Why you have
I know cost will not be imposed, but
you have taken so much time. Why cost should not be imposed?
Cost will not be imposed.
But that's not fair. I mean, cost should be imposed. That's not fair
cost
on
will
me.
not be imposed. I'll take.
Look at your 21 notice.
I'll take another
It is
two.
a faulty notice.
I'll
You
take.
should have just been fair to the court.
I'll utter only 4 sentences more and 2 minutes.
I would have appreciated if you were just fair to the court and said yes. I'll withdraw.
My lord, as I have candidly submitted, my lord has seen me in other matters.
That's why.
My lord has seen me in other matters.
That is the reason why I allowed you to.
I have candidly submitted. We are creature of instruction. My lord knows our limitations.
Creature of instruction is fine.
My lord knows our limitations.
But when a notice, have you given this notice? No. At least,
Mr. Shadab Anwar,
at least tell your client, be honest to your client that the notice which has been issued is not right.
I'm sure that I know that my lord believes
At least
me.
Don't defend something which is not correct per se on the face of it.
I know that my lord believes what I already have advised my client. Now, but ultimately, now only thing this struck my mind that
so the cost goes to your client, not to you.
No.
It's not coming from your pocket.
No. But there, my
coming
lord,
from your
there no cost. Only 2 things that formally I am citing. State of Goa.
And now don't waste my time. What are you saying?
Do not even open the paragraph. Paragraph 41, court's jurisdiction. State of Goa.
Are we disputing 11 court jurisdiction? Are we disputing any fact? Are we disputing the agreement also?
No.
Then?
No.
Limited point.
I was trying to that since existence not disputed.
Nothing is disputed. Your 21 is disputed.
Well, may I taste my submission?
And I have given judgments on 21.
May I taste my submission only in this? I have not avoided any word. I have not missed any word. I have added something.
Yeah, how can you factually incorrect things you can add? You now look at this. Wow. Not from you.
And my lord,
really hurts when
I understand. And my lord, BGS Shoma, I will not.
If I may just add these judgments.
BGS Shoma, no way. How will BJ Soma be relevant for you? Venue and seat, are they disputed here? If the seat has not been mentioned there, then the venue and the applicable laws will come and then the seat will be, that's a dicta of BJ Soma, right? How is it relevant?
Here, everything is agreed.
Yes. Who's disputing? Am I disputing? Is he disputing?
Here, everything is agreed.
Except your.
And ultimately, we came before your lordship also.
In fact, my lord,
We agreed to conduct the arbitration in.
state of Goa, Abhyavaya projects, all of them have been discussed in the judgment.
Yes, I'm also relying on that paragraph also. AFF.
Yes, now you turn.
Yes. And my lord, the judgment cited by my learned friend, I am also formally citing that. That's particular paragraph 178.
Lordship,
Grateful.
my only submission is this.
Your client has moved this, huh?
Hello?
This section 11 is by your client, no?
No, section 11 application has been drafted by me.
All right.
It has been drafted by me. If there is any dispute,
if no cost, then let him file his reply 4 weeks, 2 weeks, 8 weeks.
Lordship,
Let it be decided. All right.
My lord, I have taken so much advantage, maybe undue advantage. I am leaving it to your lordship, whatever my lord deems fit to your lordship.
Lordship, I would have concluded my submissions today because.
All right, tell me.
Grateful, my lord.
Lordship, I'll just show your lordship para 21 of the section 11 petition, lordship.
Yes.
The petitioner states that by its communication dated such and such, the petitioner invoked the said arbitration clause contained in the said purchase order. So, my lord, this is the notice at annexure J at page 53, which my learned senior's client is relying on so as to determine the invocation of the arbitral proceedings, your lordship.
Yes.
The arbitral proceedings commence as on the date the section 21 is received by the respondent, as your lordship knows. Now, my lord, at page 61, like I have pointed out, the petitioner has specifically stated that the arbitration is to be taken place at Dehradun and not at Kolkata. There is a specific averment, a negative averment, that this court does not have jurisdiction under section 11. That has been relied on in paragraph 21 in the petition before your lordship. Now, my lord, coming back to the judgment that I have placed before your lordship at para 178.
Which judgment here?
Lordship, it is 2025 9 SCC. Lordship, it is
Yes.
Alpuro. So sorry, my lord.
ASF Buildtech.
ASF Buildtech versus Shapurji Palanji, lordship, at 178. Now, the judgments showed by my learned senior friend all arises out of matters where a party in a section 34 setting, your lordship, had not been served with the section 21 notice. Some of the parties to the arbitration agreement had not been served.
Yes.
That is not my case at all.
Yes.
My case is I have been served, but the functions that you're supposed to serve in your notice under section 21 have not been done. Lordship, 178 Roman 5. I'm not even harping on the claims that have not been properly specified.
Page.
Page 178, Lordship, internal page 145. It's the 5th page from the last, your lordship.
Yes. 145.
145, para 178, Roman 5, your lordship, page 145.
Page 220.
Page 220 of the judgment. Internal page 145, the print page. So, lordship, para 178. In fact, yes, my lord, I am only hitting on Roman 5 over here. Roman 1 and 2, I have already indicated, claims not specified. But Bhagirath is a later judgment. I'll concede to that. Or for triggering the court's jurisdiction under section 11. This has been wrongly done, your lordship. This application is not maintainable before your lordship. Roman 5, your lordship will see, 178. Or for triggering the court's jurisdiction under section 11. My learned senior's client has not triggered this court jurisdiction under section 11 at all by virtue of the 21 that is being relied on. And my lord, I'll also place para 44 from Adhavya projects, which has been cited by my learned senior.
Yes.
Para 44, my lord, from Adhavya projects to the 25 9 SCC 686, cited by my learned senior, my lord, para 44. The same has been set out in Adhavya projects. My learned senior friend has relied on para 46. Para 44 says the same thing, to trigger the court's jurisdiction under section 11. I do not dispute that there is a valid and subsisting arbitration agreement between the parties, my lord. But the 21 as issued for commencement of the instant arbitral proceedings is bad. And in furtherance of the same, this application under section 11 before your lordship is not maintainable. That is the pick of my submission, your lordship.
Yes, now what are you saying?
Lordship,
Advaya,
Advaya para 44, 178 in Build Tech is, my lord, born out of 44 in Advaya project. Lordship will follow the same Roman numberings, the same findings. And 46, my lord, which my lord senior has relied on, while we agree with the decision in Alupro Building Systems insofar as holding that the notice under section 21 is mandatory unless the contract provides otherwise. Lordship, so this has arisen out of an judgment passed by the Honorable High Court of Delhi, Alupro Building Systems, which had initially laid down the functions of a notice under section 21. So these functions, my lord, have been time and again upheld by the Supreme Court in Adavya and thereafter, my lord, in this Build Tech matter. And whatever judgment my learned senior has cited is on a different conspectus altogether. It is on the point stating that the 21 is important to determine, to compute the limitation, because that is the date on which the arbitral proceedings commence. I am not on that. And I agree that the arbitral proceedings commence as and when the 21 is received by the respondent.
All right. Take down. The petitioner has preferred the present petition under section 11(6) of the Arbitration Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences that have arisen between the parties out of the purchase order dated 19/7/2024. It is the case of the petitioner that the respondent has emerged as a successful bidder for supply of, what is it, windows?
No, my lord.
Lordship, he was a subcontractor to build poly houses for farmers.
Supply, installation, commissioning, maintenance of naturally ventilated
Petitioner was
polyhouse.
a successful bidder for supplying of
Naturally ventilated polyhouse.
naturally ventilated polybags. Polybags.
Polyhouse.
Polyhouses.
Polyhouse.
These are basically storage houses for farmers.
Polyhouse. Full stop. Consequently, the parties entered into a purchase order dated 19/7/2024, valued at 1,048,607,000, inclusive of GST, pursuant to which the petitioner furnished a fixed deposit of rupees 393,60465 as security. Full stop. According to the petitioner, the execution of the project was delayed due to circumstances beyond its control, comma, including difficult terrain, comma, adverse weather, comma, logistical constraints, and delayed availability of project site. Full stop. Despite submitting, the petitioner raised invoices which were not paid by the respondent,
partly,
which were not paid by the respondent, partly, leading to invocation of arbitral dispute in terms of the purchase order. Full stop. It is the case of the petitioner that he had validly issued notice under section 21 invoking the Arbitration and Conciliation Act 1996, wide notice dated 27th March 2026, full stop. At the threshold, learned counsel for the, उसके बाद ऐसा करते हैं ना, learned counsel for the respondent at the threshold, learned counsel for the respondent states that the notice under under section 21 of the Arbitration Conciliation Act is faulty and cannot be construed as a notice under the said provision of the Act. Full stop. Learned counsel for the respondent states that the notice under section 21 records that the dispute are to be settled as per the Arbitration Conciliation Act, इसको inverted comma में कर देना, records as with the venue / seat of arbitration proceedings to be held at Dehradun as per the address mentioned in the said purchase order dated 19/7/2024 to be the address of your noticee at Uttarakhand and not at Kolkata. Full stop. He states that in terms of the said notice, the venue and seat of the arbitration as enumerated from the notice is Uttarakhand and not Kolkata, which is contrary to the purchase order. Full stop. The wrong facts enunciated in the section 21 notice makes the said notice defective and does not trigger the invocation of section 11 in terms of the Supreme Court direction in 2025-9 SCC 686 and 2025-9 SCC 76. Full stop. Keeping the dicta of both the judgments, learned counsel for the respondent states that the said notice is not in accordance with law and thus does not trigger the invocation of arbitration proceedings in terms of section 11 of the said act. Full stop. To counter the said proposition, learned counsel for the petitioner has relied on the 2026 Live Law SC 31 as well as 2025-9 SCC 686 to state that even if the section 21 notice has not been issued, that will not be fatal to invocation of the arbitral proceedings. Learned counsel for the petitioner further states that the issuance of section 21 notice is only for fixing the date of the commencement of the arbitral proceeding, as it enables the calculation of the limitation and it is a necessary precondition for filing of an application under section 11 of the Arbitration Conciliation Act. Full stop. He states that the purchase order dated 19 so and so, 19 something, itself shows that the place of arbitration is Kolkata and the arbitration clause is self-contained in the said purchase order. Full stop. He further states that since it has been wrongly mentioned in the arbitration notice under section 21 that the venue would be Uttarakhand, will not disentitle him from invoking the arbitral proceedings in terms of section 11 of the AC Act. Full stop. This court has heard the arguments advanced by the learned counsel for the parties and have produced the materials on record. It is evident from record that the Section 21 notice contains a clause wherein the petitioner has mentioned the place and venue of the arbitral proceedings at Dehradun, and rather a negative inference is to be drawn that the petitioner himself does not subscribe to the place of arbitration as Calcutta and relies on the place of the who stays in Dehradun?
I carry on my
and
work.
the place of the petitioner's business address as the venue and seat of arbitration, which is Dehradun and not Calcutta. Full stop. The Section 21 notice is itself faulty since wrong facts have been arrayed in the said notice, contrary to the submissions made by the learned counsel for the petitioner, wherein he relies on the purchase order, which clearly mentions Kolkata as the place of arbitration. Full stop. The said fact is fatal to the triggering of the arbitration clause under Section 11 of the Act. Thus, this court holds the Section 21 notice to be faulty, and the petitioner and thus the present petition is dismissed. The petitioner is at liberty to issue a fresh notice under Section 21 if so advised with the aforesaid direction. Cost wasted almost 1.5 hours. Report.
Sir, may I file my affidavit of service and the notice of motion be taken?
Affidavit of service and notice of.
And my lord, only thing in the second paragraph of the
I'll
also the termination, not only my due payment, or
this will go changes. This is just the crux of.
I
Also, there are all allegations by the petitioner are deemed to be denied by the respondent.
grateful, my lord.
Grateful enough.
Good.
You could have finished it in 2 minutes.
25.
Lordship, my Section 11 application service is complete upon the respondents.
Yes. Who's appearing? For the respondent, no one.
No one.
Yes. Where's
But-
the agreement?
Agreement is at Annexure A, page 14.
AC चला. Yeah. always. चला है. Page 14 is the
Loan.
facility agreement, right?
Yes, Lordship.
This is between Shri and the borrower, right? Where's the assignment?
Page 29, Lordship. Sorry. Yes. Page 29. No, the agreement. And the settlement agreement starts from page 41.
Assignment?
Assignment clause is at page 18.
Page?
Page 29, clause 18.
Page 29. The assignment agreement starts from?
Page 41.
No. The power to assign you're talking about? Assignment.
Settlement agreement between
Yes.
Ray and Sani is at page 41. Starts from page 41.
After the assignment, they have paid the money. Any money paid by them?
No, Lordship.
Then they have not recognized your assignment. How did they? In the matters where they have made a payment after the assignment, I can still hold that they have recognized the assignment clause. But in matters where they have not made any payment, how do we work on the assignment?
Lordship, we have issued the demand notice and
They have ignored it. They don't recognize you as a lender. Then
Lordship, they have not objected. It was delivered upon them.
delivered upon, yes, but the assignment clause is not accepted by them. Only in this matter I've seen in matters where they have paid, we can still hold that the assignment is duly transferred because they have acted in terms of the assignment. But where they have not acted in terms of the assignment, how do we hold the assignment to be correct?
Lordship, I'll take instructions whether I'll confirm whether
In
they have
25, you
made.
have to confirm. Rest of it I can still see. Not today. 25, not today.
Okay.
You get my point. The only thing I'm saying, if they have not made a payment, if they have made a payment, then they recognize your assignment. Then I have no problem. Otherwise, without hearing the respondent, I have an issue.
I'll take instructions.
And 26.
26, Lordship, this is my application for appointment of an arbitrator, Lordship. This is
Before my lordship takes it up, my lord, I'll be seeking that 1 day's accommodation. According to my instruction, my lord, there is a prior section 11 application on the sales term arbitration clause. I'm seeking that copy.
I have no instruction.
I'll get that, my lord, petition and come back. Kindly keep it on Friday, my lord. I'll receive that by tomorrow and come back on Friday, my lord. I'll give them a copy beforehand.
Not today.
Great.
So what was the fate of it?
Dismissed.
Why?
But, there was third party right involved in the arbitration proceeding which they proposed to initiate. So court said third party rights cannot be decided in arbitration proceedings. That was the ground for dismissal of that. But I do not have the copy in my hand. I have to check also tally the arbitration clause into. So I'll give them a copy beforehand and blood produce and file.
Not today.
Definitely.
27.
But item 27, 28 and 29 are between the same parties. But I will only request your lordship to kindly take up the papers of item 29 first. That's my pre-arbitration section 9 where I'm praying for some interim orders.
But I'm opposing that application, my lord, insofar as the other two items are concerned. One is my section 11 pursuant to my issuance of section 21 notice, and my lord, their section 11 as well. Your lordship on the last occasion expressed your lordship's mind, my lord, that an arbitrator may be appointed, my lord. That, my lord.
But I am not standing in the way for an arbitrator to be appointed and to be the arbitrator enters upon him. There's some urgency.
No urgency at all.
Partnership dispute. I am 50%.
All right. Urgency.
Yes.
21 notice.
But it's a pre-arbitration section, right?
That's all right.
Pre-arbitration section.
That's all right.
No, I
Where have urgency? The moment you use the word urgency, where's your section 21 notice?
But 21 notice, we have not given, but my section 11 notice is section 11
matter,
petition has
sir.
already
Doesn't
been filed.
matter. Why you have not? It's urgent, right? In DRIM, section 9.
Yes.
Arbitrator, go before the arbitrator.
Not only one request, my lord, what they are doing, my lord, partnership dispute 50% partners.
Whatever dispute.
Now, may I show the document, my lord, what he is doing?
So whatever you
My
want.
lord, kindly takes, my lord, page, my lord, kindly takes, my lord, page, my lord, 51 of my section 9 application.
That's item number 29.
Item 29.
ये 29 दियो? Yes.
Yes, kindly takes, my lord, page 51.
Yes.
My lord, this is an invoice. My lord, the partnership firm is, my lord, National Stores Supplying and Company. That's the partnership firm where we both are partners. Now, my lord, he is using the partnership firm's godown to store his own goods of a different business that he is carrying on. My lord, let him not use the partnership firm's godown.
Go before the arbitrator.
Now, my lord, he has dissolved the
File an
partnership
application,
firm.
There's no urgency. Go before the arbitrator. Raise all these issues. Yes.
Well, then Lordship takes either of the Section 11 applications.
I can appoint either of the Section 11 application with the
Lordship,
consent of the
dispose of-
parties. What is the problem? In Section 9, I can dispose it off. With
Yes,
the,
yes.
in
By
Section
consent.
9,
By
Section 9
consent.
will become your Section 17 before the arbitrator.
Yes, yes. Lordship will kindly provide that.
Okay. Take down in this.
Your lordship may also dispose of both the section 11s together.
In view of that, the Section 11 gets disposed of. Learned counsel at the outset, learned counsel of petition has filed the present petition under Section 9 of the Arbitration and Conciliation Act seeking interim relief in the nature of drawing of an inventory lying in the godown mentioned in annexure D.
Yes.
Annexure inverted comma
Annexure D
letter
on
letter D inverted comma close. And to take physical possession of the goods / merchandise belonging to the sole proprietorship concern of the respondent, namely National Export Company, and to sell the same by public auction or private treaty. Further, to deposit the sale proceeds from the sale of the said merchandise belonging to the sole proprietorship concern of the respondent in an interest-bearing account with a nationalized bank. Learned counsel for the, without getting into the dispute, learned counsel for the parties submit that they are willing and agree, they are willing and agree to the appointment of an arbitrator to adjudicate the dispute between the parties with the consent of the parties. Mr.
anyone subject to
Give a name.
I leave it entirely to your lordship.
Mr. Amitesh, Senior Advocate, Amitesh Banerjee.
Takes are not to take. So 90 lakhs will be the total quantum.
That's all. Then we have somebody else. We can appoint Mr. What's your name? Mr. Gomes? Mr. Gomes?
Yes.
Mr. So and so is appointed as the learned sole arbitrator to adjudicate the dispute between the parties. All issues pertaining to arbitrability, maintainability, limitation, claims, counterclaims shall be left open to the arbitrator to be decided in accordance with law. The learned sole arbitrator shall enter reference in terms of Section 12 of the said Act. He shall be entitled to a remuneration in terms of the fourth schedule or with the consent of the parties. With the aforesaid direction, the present petition stands disposed of.
Only one
Yes.
only one indulgence, my lord, since affidavits were not called from the section and may only be recorded, my lord, that we deny and dispute all allegations made in the section. Leave that. Very well. I leave it.
Let me make this order in Section 11. ठीक है. Learned counsel for the petitioner वो जो है ना have filed a application under section 11 so and so. एक में कर दो. Section to why to section 11?
Because my lord, my 21 notice, my lord, we had.
So you also asked for the same thing.
Yes,
Yes.
my lord, my
I
application
am
is
not
prior in
commenting
point
on
of
this.
time. Immediately thereafter, he has filed.
एक में करो section 11 में that application filed under section 11(6). At the outset itself, learned counsel for the parties consent to the appointment of the arbitrator. With the consent of the parties, so and so is appointed as the arbitrator. All issues pertaining to so and so is left open to be adjudicated by the learned arbitrator. And then say, ठीक है. उसके बाद करना section the other section 11 in view of the so and so. The present petition stands disposed of since the same has become infructuous. And section 9. Learned counsel for the petitioner seeks to withdraw the present application. Both section 9 withdrawn, file a second.
I'm deeply afraid.
Got it? इनके वाले में कर दो. Your this first item is 27.
Yes, 27, my lord, AP 562 is my section 11.
562. ठीक है.
Kindly does not provide that my section 9 is withdrawn. Kindly dispose it of on the ground that your lordship has appointed.
Since the section 9 में कर देना, since in AP so and so the arbitral tribunal has been constituted, learned counsel for the petitioner seeks to withdraw the present application to file appropriate proceedings under section 17 before the learned arbitral tribunal.
Grateful.
उनके भी section 9 में same order.
But we have not filed a section 9.
Oh, you don't have it?
No, no, no.
You have just
one section 9, two section 11.
Two section 11, one section.
One section.
Deeply applied.
Great.
Section 9.
View of future.
I'll just come.
No, 30.
I'll just come back in one. Which one? Why sleeping? 6 p.m. Oh, but we didn't fix. ये fix ना किया ये Who's it? What is it? Yeah. Did we fix this matter? If you lordship has still please to fix the matter. Wait for some time. Let me just run.
30.
My lord, I appear for the petitioner in item 30, my lord. My lord, I'm only praying for not today, my lord, because I'm not well, because I'm
Yeah,
not
I
well,
appear
my
for
lord.
the rest.
That's why
I appear for the
appear before your
respondent, man.
lordship.
I'm not standing in the way. I'm not standing in the
I'm
way.
only praying for not today.
Not
So
today.
item 30 to
On item
32.
30 to 32, my lord. 30, 31 and 32.
We'll have it on Monday. Keep it
Lordship,
Very
lord.
well.
Monday. Keep it on Monday.
Yes.
So grateful.
Next.
Item 33.
33 is our section 11 application, my lord.
Yes.
We have served the respondents, my lord. They have received. I'm filing affidavit of service. This is the agreement related to finance agreement, my lord. The arbitration clause is here at page 45, clause 19. Page 45, clause 19 is the arbitration clause and the forum selection clause.
This is a. You have served them, right?
Yes, we have served, my lord. The respondent has received, delivered, my lord. It appears from the arbitration clause is at page 45, my lord, clause 19. This is the arbitration
Page
clause.
40.
45, clause 19.
Contract is what? Loan.
This is a loan transaction between the parties, my lord.
Starting from
Page 45, my lord, clause 19 is the arbitration.
contract starts.
Yeah, loan start, my lord, from page 19, my lord. The facility agreement
Facility.
between the borrower and the borrower, my lord. And particulars which due, my lord, we have mentioned in the petition, my lord, at page paragraph 10, page 7, my lord, the amount due.
Uh, 21 notice. Page.
21, yes,
Loan
my,
recall. Did you recall the loan?
yes, my, I have recalled the loan. Loan recall notice is page 60, my lord. 60. And thereafter 21 notice has been issued. The 21 notice is recall is page 60, my lord. And thereafter we have issued notice under section 21 at page 62. The section 21.
Did they have replied?
They have replied, but they have objected that their reply is at page 65. They have objected that they have committed the Supreme Court guidelines regarding the independent arbitrator and so on. Page 66, clause 6 is the main important point. So we have filed this section 11, my lord, for.
The petitioner has filed the present application under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of an independent and impartial arbitrator, sole arbitrator, to adjudicate the dispute and differences arising out of the facility agreement. What is the date of the facility agreement?
Facility agreement date is, my lord, February 22, 2005, 2025, my lord, in the
2nd February 2020.
bottom of the page, my lord, the each signature is there and the date was mentioned, my lord. February 22nd, 2025.
The petitioner is a non-banking financial company registered under the Reserve Bank of India Act 1934 and is engaged in the business of providing financial assistance to its customers. Full stop. According to the petitioner, the respondent approached the petitioner for grant of a business loan, pursuant to which the parties entered into a facility agreement dated same 22nd February 2025. Full stop. Under the said agreement, the petitioner sanctioned a loan of 2544250 in favor of the respondent, who agreed to repay the same in equated monthly installment and undertook to remain jointly and severally liable to the repayment of the said loan. Full stop. It is the case of the petitioner that the respondent committed persistent default in repayment of the said installments. Full stop. Consequently, by notice dated 9th May 2026, the petitioner recalled the loan facility and called upon the respondents to pay the outstanding dues. Full stop. As the respondent failed to comply with the demand, the petitioner invoked the arbitration clause as contained in the arbitration agreement by issuing a notice under section 21 of the said act dated. What is the date of this notice? 12 June 2026. Full stop. It is contended by the petitioner that the respondent replied to the said notice on 15/6/2026, declined to proceed in terms of the arbitration agreement and instead proposed that the dispute and instead refuted the very mechanism of the arbitral proceedings as contained in the said agreement. Full stop. According full stop. This court is of the prima facie opinion that a valid loan agreement, facility agreement had been entered into between the parties. Full stop. The petitioner had duly sanctioned the loan to the respondent. Full stop. The respondent defaulted in the payment of the said loan. Full stop. The petitioner had invoked the arbitration agreement as contained in clause 19 of the facility agreement dated 22nd February 2025, which is not in dispute. Full stop. The dispute sought to be referred arise out of the said agreement. Full stop. The petitioner had duly invoked the arbitration clause by issuing a notice dated 12 June 2026 under section 21. Though the respondent declined to proceed in accordance with the agreed mechanism and neither proposed any alternate mechanism for resolution of the dispute. Full stop. Consequently, no arbitral tribunal has been constituted in terms of the agreement. Full stop. In the facts of the present case, this court is satisfied that the agreed procedure for appointment of the arbitrator has failed, thereby warranting exercise of jurisdiction under 11(6) of the said act. Full stop. Accordingly, so and so is appointed as the arbitrator to adjudicate the dispute arising between the parties out of the agreement dated 22nd February 2025. Full stop. How much is the amount?
19 lakhs, madam.
We'll pick some young member at the bar. Suggest somebody.
हाँ? और कोई appoint Shaunak Mukhopadhyay or Priyanka Shah, whatever, my lord. They are member of the bar.
Give the details.
Shaunak Mukhopadhyay number. Shaunak Mukhopadhyay, junior member of the bar, madam.
Give the details. Mr. So and so is appointed as the learned sole arbitrator. Section 12(5). Despite service non-appearance. No, maybe. Good.
My lord, 34, your lordship, I appear for the respondent.
Yes.
My lord, I appear for the respondent in 34.
Yes, tell me, who's for the petitioner?
My lord, I have not received a copy of this application as of yet. That is my instructions.
Nobody is here, none for the petition. In the interest of justice, adverse orders are deferred. List next week.
Next week. Very well, your lordship. Deeply obliged, your lordship.
Next week.
$35.
Lordship, I appear for the petitioner. This is my Section 11 application. The dispute arises out of a loan agreement, Lordship, dated April 4, 2025, for a loan amount of rupees 20 lakhs 15,437, Lordship. Kindly comes to page number 10. The loan agreement.
April 2025.
4th April 2025, Lordship. Thereafter, Lordship, the respondent started defaulting, and the loan agreement was terminated by issuing a loan recall notice dated October 16, 2025, your lordship. And the outstanding dues mentioned in the loan recall notice was 21 lakhs 85,963, your lordship. Page number 34. Lordship, no reply came from the respondents. Thereafter, we issued a Section 21 notice is on April 14, 2026, Lordship, which is on page number 36. If your lordship kindly comes to page 20, lordship, the arbitration clause is there, clause 8 of the agreement.
Yes.
And
8.5.
Lordship, clause 8 is the arbitration and jurisdiction, and clause 8.9 is talking about the jurisdiction.
8.5 also talks about.
Yes, your lordship.
The seat of arbitration is 8.5.
Yes, your lordship.
That's the governing clause, 8.9. 8.5 is relevant. Take down. The petitioner has filed the present petition under 11 first paragraph ballot, seeking appointment of a sole arbitrator to adjudicate the dispute and differences arising out of the SME business loan agreement dated 4th April 2025. The petitioner states that under the aforesaid business loan agreement, it sanctioned an amount of rupees 2015437 in favor of the respondent as a business loan, full stop. According to the petitioner, the respondents committed persistent defaults in repayment of the monthly installment and other obligations under the agreement, full stop. Consequently, the petitioner issued a loan recall notice dated 16/10/2025, calling upon the respondents to pay the outstanding dues, full stop. It is the case of the petitioner that the arbitration clause contained in the arbitration clause 8 contained in the SME business loan agreement. The petitioner had invoked the same by issuing a notice under section 21 of the said act dated 14th April 2026, full stop. She further states that the notice was duly served upon the respondent, though the respondent neither responded to the said notice nor took any steps for constitution of the arbitral tribunal within the stipulated period. Full stop. Learned Counsel further states that Clause 8 of the Business Loan Agreement provides for resolution of dispute through arbitration with Calcutta as the seat of arbitration. Full stop. It is submitted that despite invocation of the arbitral proceedings, no steps have been taken by the respondents. Full stop. This court has considered the submission advanced by the counsel for the petitioner and has as well as perused the materials on record. The existence of the arbitration agreement contained in clause 8 of the business loan agreement dated 4th April 2025 is not in dispute. The dispute sought to be referred arise out of the said agreement. Full stop. The arbitration agreement was invoked by the petitioner by duly issuing notice under section 21 on 14/4/2026. Full stop. Admittedly, no arbitrator has been appointed pursuant there. Full stop. In these circumstances, this court is satisfied that the agreed procedure for appointment of arbitrator has failed, thereby warranting exercise of jurisdiction under 11(6) of the Arbitration Conciliation Act 1996, appointing so and so as the sole arbitrator to adjudicate the dispute and differences arising out between the parties in terms of the loan agreement dated 4th April 2025. Who shall we appoint? How much is the amount?
Lordship, if your Lordship deems,
Yes,
Proceed Dev, learned advocate Proceed Dev, he's a member of the bar.
give the detail.
I do not have the details right
Then
now.
I'll appoint from the, what's your name? No, you. Yes. How many years? 30. Shall we appoint you? It's a small claim. Mr. Rohit Mukherjee has been appointed as the learned sole, just give your details, as the learned sole arbitrator to adjudicate the dispute between the parties. And reference in terms of section 12, remuneration, fourth schedule, or with the consent of the party, all points regarding maintainability, limitation, arbitrability, claim, counterclaim shall be left open to be adjudicated by the learned sole arbitrator. A copy of this order shall be communicated to the learned arbitrator to take necessary steps with the aforesaid direction. The present petition stands with this. Yes, affidavit service taken on record. Despite service, none appears for the response. Yes. Next, just give me the ये इसमें changes करना ये. What is the date of the agreement?
Lordship, the date of the agreement is April 4, 2024.
Date of the agreement, April 4, 2024. Arbitration clause. Arbitration
Is
clause.
it the next matter, Lordship? The next matter, I would be withdrawing your Lordship on instructions.
Learned
And
counsel for the petition seeks to withdraw the present petition. The same is dismissed.
36.
Lordship, for ease of reference, may I hand over the chart for item number 37?
Yes, that's what I want.
37.
Okay. Date of agreement, loan amount, notice, loan recall notice here. Same, Mr. Banerjee, same person appointed as the arbitrator. Mr. Mukherjee.
একই appointed হলো, 35 আর 60
Next.
যাতে এরকম যাবে হ্যাঁ আর not 38
38 I am for the petitioner.
By Mr. Devishar. Not today, not today. That's what he wants. Not today. Yes, just a minute.
39.
I'm for the respondent. Lordship, behalf of the petitioner in this matter. Lordship, item number 39.
Yes,
I am
madam.
appearing. Lordship, this is my section 11 application. Lordship,
Yes.
the disputes between the parties arise out of a development agreement, Your Lordship.
I don't see you, madam.
Lordship, I am really, I am
Not today.
apologetic, Your Lordship.
Not today.
Lordship, Lordship, may I, Lordship, the video is on now.
Your voice is not clear, madam.
Lordship, the section 11 application, Your Lordship.
Not today, madam, not today. Yes.
Gratefully, Your Lordship.
40. 40, I am appealing for the petition under section 11 application.
Yes.
Hardbis has not been affected. Kindly
Learned
keep
counsel for the
1 week
petitioner
time.
seeks and is granted 2 weeks time to effect service upon the respondent or respondents.
I'm not the petitioner.
So you'll serve the respondents. You're seeking time. to
No,
serve.
no. I have not served it yet.
That's what I'm saying. You're seeking time to serve.
Yes.
What else am I recording, sir? Seeks and is granted time to serve upon the respondents. Affidavit of service to be filed on the next day. 2 weeks time to file.
No, it's 2 weeks time.
Just after 3 weeks.
I'm the.
Affidavit service.
Not yet.
Hang पड़ेगा लोग होता है.
Now 41.
Lordship, item number 41, I am praying for not this week. The copies have already been posted, Lordship, but it has not yet been delivered.
All right, not this week.
Malad, I appear for the respondent. Malad, may a copy be served upon me, Malad? I appear for the respondent, Malad. In the causes, Malad.
41. Which item?
Yes. 41, Malad. 40.
He's asking for not this week. They are appearing.
Lordship, not all have not been.
All have not been served. All respondents have not been served, Mr. Singh.
I have also not been served. Very well, Malad. Let it be not this week in that event.
Yes.
Lordship, grateful.
42, 43.
Now 42. 42.
My Lord, we are for the respondent.
Who's for the petitioner?
My Lord, Khaitan and Company, Mr. Ratnanko, that was.
All right, not today. Next, run the list.
42, 43.
Not today. 42, 43 connected, not today. Next. 44.
44.
My Lord, 44, my Lord, my petition, my Lord, I'll indicate, my Lord, award passed against us. My Lord, in a judgment delivered by my Lord, the award was set aside. My Lord, after which we filed this application for return of security, they went up in appeal, section 37. The award was modified. We have preferred a special leave petition before the Honorable Supreme Court, my Lord. It's pending. My prayer today before my Lord is, my Lord, let this go out of the list with liberty to mention, my Lord. The matter is pending before the Supreme Court.
All right, learned counsel for the petitioners, learned counsel for the parties submit that the SLP number. Give the SLP number.
My Lord, I'll just give my advocate on record is there.
That a special leave petition has been preferred in this matter, and the same is pending adjudication before the Honorable Supreme Court. We pray for this matter to go out of the list
With liberty to mention, my Lord.
At an appropriate stage.
My Lord, I'll hand over the number to my Lord's officer. I mean,
let this matter go out of the list with liberty and prayer.
Forty-five.
Yes.
Award debtor with an MSME award, my Lord. The award, my Lord. Lastly, the stay was extended on the 10th of June for a period of 8 weeks. I apologize, my Lord. We filed an application seeking extension of the stay on the award. In the meantime, my Lord, the award holder has filed an application seeking recalling of the stay. In that, my Lord, we have filed our opposition.
Who's appearing?
Lord, I appear for the respondent, Lord.
Yes, tell me.
Lord,
My lord, I have filed an application, my lord, seeking for recalling of the stay. My lord, on the ground, my lord, that sufficient deposit is not made. They have filed their affidavit in opposition. I believe, my lord, we have received a copy. My lord, may kindly give us 2 weeks, my lord, to file our reply to that, my lord.
That's in GA, right?
Well, GA2,
GA2.
IA GA2 of 2026.
Learned counsel for the respondent seeks GA2. Learned counsel for the respondent seeks and is granted 2 weeks time to file his reply to the affidavit in opposition.
Oh, yes, my lord. The interim stay is expiring today,
The
10th of June 2026.
which application is that?
My lord, IAG number 3 of 2026.
GA3.
My lord, page
interim
5.
order.
Page 5 is the prayer. And my lord, the last order is 10th of June, page 21. Page 21 at 23.
Page 21.
21 at page 23. The top paragraph, my lord. That as it may, let me read. Since the petitioner has been enjoying the stay of the award dated 20th September 2024, it should be, my lord. It has wrongly gone down as 2025.
The interim order granted earlier, which has been extended from the interim order granted on 10th of June, right?
My lord, granted firstly on 15th of September 2025.
Of September 2025, which has been extended from time to time, is further extended for a period of 8 weeks or 6 weeks or 8 weeks.
8 weeks, my lord. Last was, my lord, 8.
8 weeks.
My lord, 6 weeks is sufficient.
GA3 में करना. This. The petitioner has preferred the present application seeking extension of the interim order granted earlier by order dated so and so.
15th September is on, my lord, page
Interim
19.
order granted earlier has been extended from time to time for the reasons stated in the order itself. Full stop. In view of the same and for the reasons stated in the application, the interim order is extended further for a period of 8 weeks. GA3 with the opposite direction, GA3 is disposed of.
Grateful.
My lord, one more prayer, my lord. The affidavit in opposition, we are filing a copy in the court today, my lord. For GA2.
Affidavit in opposition, GA2 में लिखना. Affidavit in opposition filed by the petitioner.
My lord, pray for the petitioner.
Petition.
Obliged.
So grateful, my lord. Deeply obliged.
Is the matter after 5 weeks? Just take that specially fixed matter.
Grateful, my lord.
3 o'clock.
Next matter at 3 p.m. Sorry. No. I know 96.
Will we be able to finish it? Mr. Shah?
He is continuing. I haven't started as yet.
How much time will you take?
But I will take some time because my lord, I have to go to the contractual clauses and to show that the contractual clause, arbitrator has traveled beyond the contractual clause. 96 আমাদের তো 76 আমাদের এটা কোনটা
কোনটা করবে আমাদের
হ্যাঁ GPM বল দেখতে পাচ্ছ না চেহারাটা দেখে বুঝতে পারছো না
আমাদের ব্রিফের চেহারা
হ্যাঁ 96
আমাদের ব্রিফের চেহারা ঘিরে আছে
Tomorrow.
Including that even day after tomorrow because tomorrow I have something. Day after tomorrow.
Tomorrow Friday it won't happen.
next Wednesday subject to your lordship kind of approval.
Next Thursday.
Next
Thursday 3 o'clock.
Thursday means
Thursday 3 o'clock. Thursday your lordship takes up.
Thursday I'm taking
takes
these
up that
34 petitions. I'm keeping a day for that.
A one-line order may be given, otherwise there will be difficulty.
Third counsel for the parties, list on next
Happy.
first.
Go on. Along the view. Thank you so much. Okay. No.
How much time will it take?
No, next time
I will take much time. He is saying I will take very small.
But I have 4 headings on 4 principles. I will show some case laws and I will take your lordship quickly through the contractual clauses. Mainly it is beyond the contract and difference of 1940 and 96.
Next Thursday.
उनका नाम और नंबर लिख के रखना arbitration. To give your details.
I will not take much time. Huh?
Deeply
13 तारीख. Next Thursday. Thursday week.
No, next Thursday. Next Thursday.
No, next Thursday is tomorrow, my lord.
No, next Thursday.
Thursday week though.
Thursday week.
Thursday week.
13th. 13th. Renew you. Six or whatever. That's it. Oh, sorry. And now 46.
I appeal for that award. Well, the principal amount, awarded amount is 40 lakh. Interest is 10%. Well, it comes to 38,000 lakhs and odd. So, 78,000, 78 lakhs, 87,000 they have to secure. They have filed a 36-2.
Your Lordship, I appear on behalf of the petitioner. Your Lordship, I pray for an adjournment today. Your Lordship, as
91 lakhs.
my senior means not available
Not
today.
today, not today. Then.
Wait
Not
for the
today.
Lordship.
Not.
82 lakhs and odd they have to.
Not today.
Motion section 9, item 47 with 48.
Yes, no.
Item 47 and 48. May I pray for a note this week? I'm being led by Mr. Shobhasati Chaudhary.
Adjourned it because just to take instruction.
My learned senior friend has sought several times in adjournments were sought for the petitioner.
No,
I'm only seeking. He's in difficulty. Mr. Chaudhary is in difficulty.
You are supposed to take instructions only. My disputes under section 21, I am agreeable to go to arbitration.
Yes.
That is the only thing. Both the matters can go to arbitration.
My lord, I fully appreciate. I have a leader in the matter. My lord will kindly not put the gun on my shoulder. That's my only prayer. My lord, allow my senior to address. My lord, I'm only asking for not this week, my lord. On Monday, my lord, we'll do it. We'll do it. Whatever it is.
My section 21 has to go to arbitration.
You were supposed to take instruction. What happened?
My lord, if my lord recalls, here we had taken instructions that we were agreeable to a composite reference comprising the petitioner before my lord as well as the holding company of the petitioner, because the entire transaction, as we've stated in our affidavit in opposition in the present proceeding as well.
Holding company is not a party to the arbitration proceeding.
Of course, my lord, but my lord,
no,
we've sent a section 20. I'm sorry, my lord.
You were supposed to take only instruction in terms of the main company, not the holding company.
My lord will recall here the proposal came from my client.
All right, you come back on Monday, we'll finish it. If you don't come, we'll...
Then I'll press my section 9. Let it be
on merits,
understood.
my lord. Of course.
All right, fine. Monday.
Deeply obliged, my lord. Deeply obliged.
Better than Monday, 46, 47, 48.
47, 48. That instruction is not necessary because my section 9, my section 21. The Lordship will have...
For that, there is no instruction. We'll finish it there.
Only
Can we refer to arbitration? I can only say that give me liberty to move my section 17 before the arbitrator. That's the only thing.